All right. Well, we will come back from a long recess, probably the longest recess I've ever known to happen in a committee public hearing. This is the public hearing for the committee on the Committee on Children. We are resuming at 4:06 p.m. and I know that people are still getting their bearings straight since we had to reassess with a bunch of folks needing to get home for weather condition reasons, related reasons. But with that said, the next person on our list that we are that is testifying that we are waiting for is Representative Jaime Foster, but I do not see Jaime Foster. And after Jaime Foster is the Honorable Minority Leader Vince Candelora, who is also not here. So with that said, we'll go straight to number 5, which is the Office of Child Advocate, Christina Ghio. Christina?
Good afternoon, Representative Paris. Thank you very much. I can't see who's here, but good afternoon to Representative Paris, Senator Marr, Representative Dauphinais, and Senator Perillo, and all of the distinguished members of the committee. Thank you for giving me the opportunity to testify. I am testifying today on Senate Bill number 6 and also raised Bill 5004. With regard to Senate Bill 6, I just want to comment on sections 2 through 5. Section 2 requires certain eligible districts to provide school breakfasts and school lunches to all students at no charge. Connecticut's food insecurity rate is 17%. And that is across the state. Of those who are food insecure, the Feeding America estimates that 38% fall below the eligibility threshold for federal nutrition programs, meaning they're not eligible for public benefits that would ensure that they could buy food. And as I said, it exists across our entire state from the southwest corner, where it's 12.2%, to the northeast corner, where it's 15.3%. And students who participate in school breakfast programs have improved attendance, behavior, academic performance, and academic achievement, as well as decreased tardiness. And that's based on decades of research. So I would urge the committee to support that section. I want to comment on section 3 as well, which would prohibit people with certain convictions, crimes related to minors in particular, cruelty to persons, risk of injury to a minor, sexual assault involving children, from sharing a primary residence with a minor child, except for that person's biological or adopted child. And section 4 would create a notification requirement that the Department of Corrections notify DCF when one of those folks is being released, so that DCF can determine if there's an open case. And I just want to say, with regard to that, a couple of suggestions. One would be to clarify what DCF is to do with that information when it's received. If there is an open case, then we think it's important for it to be clear that they're expected to do an assessment. We would also suggest that the notification include information about any assigned probation or parole officer and ensure that DCF communicates with the assigned probation or parole officer. We did provide a little additional detail, but I know we're late in the day, so I'm going to continue to move on. I'm not going to read everything I've put in my written testimony. Section 5 has been discussed earlier. I do want to clarify a couple of things with regard to that section. So I think it's important that we clarify again the expectations of what DCF does with that information when they receive notification and there is an open case. The language right now says to put a notation in the file. We think it's important, again, for that information to get to the caseworker so that they can assess the situation. It may be that they already know that the parent has a plan to remove their child to attend private school, and it's no big deal. but it's important that the caseworker receive the information, that the caseworker conduct an assessment based on the facts as they're presented to them. I do want to mention also, this question of whether or not DCF is aware when they have an open case, whether DCF is generally aware that a child is removed. I think generally that may be true, but certainly in the case of Matthew Tirado, which we have spoken about in front of this committee before, who died due to starvation and abuse in 2017, his sister was removed from school while the family was under court-ordered protective supervision. DCF did have authorization for the school to communicate, to get information from the school. They contacted the school and confirmed that the child was attending just months before months before he died. So they contacted the school confirmed that the child was attending. 1 month later, she was removed from school, withdrawn from school. DCF was not notified, and shortly thereafter, DCF closed its case. There are cases also in our 2025 investigation of children who had open cases. The family had an open case and the child was removed during that open case, and DCF had no knowledge of that. So we do think it's important to find a way to ensure that DCF is aware when a child who has an open case, again, a family has an open case, is aware that the child has been withdrawn. I want to move on to Raise Bill 5004. We applaud the committee for working to increase transparency and accountability with respect to DCF's child protection work. I think it was mentioned earlier, there are several oversight committees. There isn't an oversight committee. The Transforming Children's Behavioral Health Committee focuses on mental health. The Juvenile Justice Policy and Oversight Council focuses on juvenile justice. There really isn't a similar legislative body that focuses on child protection. And we think that that's critically important. The WANF consent decree ended in March of 2022, ending 30 years of external oversight of the Department of Children and Families. And what that means is we lost proactive qualitative case review that was happening by an external body on a regular basis, matched to performance measures and outcomes that we expected from the department. And it's really important that we create something to ensure that we have that kind of oversight and information sharing. And most importantly, the reason for that information sharing and that transparency, at least one of the reasons, is to be able to have honest conversations about where the gaps are and what we can do to address them. So we applaud the committee, and we are happy to work with the committee on this bill. I do want to mention there are a number of things in the written testimony. I'm not going to go through them. I do want to mention with regard to sections 4 and 5, the grants that are available to caregivers and fictive kin. In the drafting, it appears to me the way that the bill is currently drafted, that non-relative foster parents are excluded from those grants. I should be more specific, non-relative foster parents where the permanency plan is not another planned permanent living arrangement. So I don't know if that is intentional or a drafting error, but I do I would urge the committee to make sure that all foster parents are included, non-relative foster parents, relatives, and fictive kin. I'm going to stop there. I'm sure the committee has questions. I did provide lengthy testimony and feedback with regard to the bill, and I'm happy to answer any questions you may have.
Thank you, Ms. Ghio. We appreciate your testimony. First person up with questions is Representative Mastro-Francesco. Ma'am, you have the floor.
Thank you, Mr. Chairman. Thank you for Christina for coming in to testify. I just wanted to get some clarification. In your testimony, you mentioned that it's important, I'm referring to Senate Bill 6, that if it's an open case and a child is withdrawn from school, that the DCF should be notified. So my question is, it's an open case. They're already notified. If they're not doing anything, then they're not doing their job. It's an open case. They should be checking on this child automatically because it's an open case. And I just wanted to know how you can respond to that. To me, it's an oversight of DCF.
Sure. So I already mentioned the Matthew Tirado case in which they had checked a month before, they confirmed, and then the child was withdrawn. That was a case where there was court-ordered protective supervision. But there are other cases, for example, when there is an investigation happening, the parents can refuse to sign authorizations, right? So in our 2025 investigation, we gave 5 case examples. 3 of those 5 include children who were removed while the case was open. One of them DCF was aware of and had communicated with the parent about the parent's plan to remove the child for homeschooling. 2 of them DCF was not aware of. And the way that that happens is that there was sort of partial cooperation. So there was an investigation, there was a substantiation. They were considering filing petitions. This is in one case. The family had had 12 prior accepted reports. This report was substantiated. They were working with the family. The family had counsel, refused to sign any authorizations for the children in the home, and they cooperated with some treatment that DCF wanted the father to do. In that case, the substantiation was with regard to the father leaving firearms within the reach of the children during a mental health crisis. And so there was therapy that they wanted the father to do, and some other services which the father engaged in, and they communicated. They signed authorizations to allow DCF to confirm the therapy, but they did not sign authorizations for DCF to obtain information from the school. So DCF could not, they did not have sufficiency to file petitions because the father had done the therapy that they requested. And what we learned when we did our investigation was that there was nothing in the DCF record. That child was removed while that was all pending. While all of that was happening, the child was removed, withdrawn from school. And DCF was not aware of it. There was no documentation anywhere in the DCF record that indicated that the child was being homeschooled. And there was nothing in the observations of the home that indicated that the child was being homeschooled, but he was withdrawn. There was a second case that was similar in that there had been 11 accepted reports. The most recent substantiation was for educational neglect of an older sibling. And again, the DCF in that case brought the parent to court. The parent had an attorney. The attorney provided DCF with letters from a mental health provider, from medical providers. And then because they had that information, they made a decision that they needed to close the case. The child who was subject to the report, they were able to confirm that that child was in attendance at school and they had had no further reports, but the parent would not sign an authorization with regard to the other children, and a younger sibling was removed while that case was pending. DCF had no knowledge of it. So it does happen. And in circumstances, either because the parents have refused to assign an authorization, or because even though the school may know that DCF's involved, the person who works in the office is an administrative person, takes the paperwork that or the email or whatever notifications given to the school that the child's going to withdraw, they process it. That person very often has no knowledge that there is an open DCF case. And so that's what happened in Matthew Tirado's case, right? There were people at the school that were aware. The school had made reports, but when a parent withdraws, that goes to an administrative person in the office who enters it into the computer, and so that person does not know to notify DCF.
Okay, so it seems to me that I understand that, but it seems to me that it's still an open case, and we heard a testimony from DCF on the issue of notifying DCF when a child is withdrawn from school. She said that they would already know that because it's an open case. So my question is, having the Department of Education notify the DCF on every child that withdraws from school for whatever reason, whether they're homeschooling, if there's no, what is the goal? What are you trying to achieve by doing that? How does that help anything? Because I would say most of the parents obviously withdrawing their kids from school. Maybe they want to homeschool them. Certainly it's their right to do it, but I don't see how that helps the situation at all, because DCF is already on it if they have a case. If there's no case, what do they do with that information?
Yeah. So first, when you say what are you trying to achieve, I just want to be clear that I did not propose this language. This does not come from OCA. This is language that's in the bill that I'm responding to. So I do want to clarify that. And I think sort of already spoken to whether DCF does or doesn't know. Sometimes they know, yes. Sometimes they're involved with the family tells them, or they've talked with the school, but there are absolutely times where the child is withdrawn, when DCF has an open case and they're not aware. The question that you raise about, well, what happens with this information that DCF is getting if there isn't an open case, I think is a really valid question and an important one to figure out if this is the way that, one of the things the state wants to do to address this problem. I think that I don't see any reason why DCF would need to or should retain that information. I think it would be appropriate to include language that requires that information, to be expunged, to be destroyed. I think we could, the legislature, we'd be happy to work with the legislature to figure out language for that. But I don't think there's any reason for DCF to retain the information if that family does not have an open case, right? If they have an open case, go to the caseworker should, take a look and say, oh, maybe the caseworker already knows. If they don't know, then that's going to raise some questions, and they need to say, hey, we just got a notice that you moved out of state, right? You withdrew your child because you were moving out of state, and here you are, you're still here, right? Or we, for whatever reason, there's a withdrawal, they weren't aware, they should be assessing that. But I do think it's appropriate to include language that requires that information to be expunged if that family does not have an open case.
Okay, thank you. Thank you, Mr. Chairman. Just through you, just one comment, Mr. Chairman, through you.
Yes, ma'am.
I understand where you're coming from. I really don't feel that it's necessary for the DCF to be notified because there's nothing to achieve. They already know, like I mentioned before, and I don't want to be redundant, that there's an open case. And I just think we are fishing and trying to figure out a way at some point to regulate homeschooling. And clearly, if it's an open case, maybe there's a problem at DCF. They're not doing their job properly. There's a lack of communication. Something there could be going on. But to subject everybody to have them reported to the DCF, we're almost assuming that they're guilty, that they're doing something wrong. And if there's certainly no case on it, they're doing nothing wrong. So there's no need for us to know. But I thank you for your testimony. Thank you, Mr. Chairman, and I appreciate your concerns. Thank you.
Thank you, Representative, for your questions. Representative Ann Dauphinais, the good ranking member of this committee. Ma'am, you have the floor.
Sorry, I had to unmute myself. Thank you, Mr. Speaker. Nice to see you. Or Mr. Chairman. Sorry.
Thank you, ma'am. That is not a job that I seek, or do I want those problems? Thank you, ma'am.
Hello, Commissioner. Good to see you today. I have so much to unpack with this piece of SB 6, in particular, Section 5, and you hit on a few things, but the one thing, let me just make some comments and then you can respond, but you said that this was not something you put in, but you do support it. So I would like to just kind of run with that and say, so what I'm looking for is a couple of things. One, I want to know if there's any other situation out there in which DCF would be notified of some family or somebody of something that they did that was completely legal. In other words, they didn't do anything illegal or wrong. They simply withdrew their children out of school, or one child or whatever, and now we're sending a notification to SDE, and SDE is going to send a notification to DCF. There's been, no, thoughts of perhaps neglect or any kind of problem that would trigger DCF to be involved. And now we're starting this whole new precedent, because I can't think of anything in which DCF would be notified about something that somebody did that was completely legal. Furthermore, I think that this is, I think Rep. Lanoux said it earlier with regard to this being in reverse. Now, if there were children on DCF or had a substantiated case, then it would make more sense to me to have the school have a list of those children. And if they were withdrawn, then that would be a trigger. They're already part of the system. They're substantiated case. Furthermore, I would add that the commissioner did say that that is part of their job, to know where they're going to school, what they're doing, where they're attending, who they're living with, so on and so forth. You made a lot of comments about the Matthew Tirado case, which I do remember. That was my first term in service. And Matthew Tirado was the child that was part of DCF. The sister was not. And Matthew Tirado was not being homeschooled. There's no record of that withdrawal. So you kept referring back to that as an example, but I guess I'm not seeing what you're seeing. From what I understand with Matthew Tirado, the judge dismissed the case. Nobody had laid eyes on him, and he died shortly thereafter. But I'll let you respond to some of what I said, if you would, please.
Sure, thank you. So, so I'll take it in parts. First, I do want to clarify that the piece of the language that says that the school district will notify the State Department of Education when the student is withdrawn, that already occurs, right? Because the State Department of Education has collects information on all of our public school students. That's how we get our chronic absenteeism data. That's how we get our discipline data. That's how we assess how well our public schools are doing. And they are not allowed to list a child as being withdrawn from their school, right? And that's important when a child's chronically absent. We don't want them removed and from those lists, because we want to be able to track whether kids are chronically absent. So there are rules about when they can withdraw a student, but they provide notice to the State Department of Education whenever a public school student is withdrawn and what the reason is, right? So that piece already happened. So I just want to clarify that. Your question of whether there's any other circumstance where DCF is notified about a parent, sort of similar fashion, about a parent that's doing something that is otherwise legal. I'm not aware of another circumstance. And I think what the state really has to grapple with is, sort of first, there is a problem in terms of people who use our lack of regulation to remove their children from public school and isolate them and harm them. We have seen a number of cases. We do need to figure out a way to address that issue. And I think the piece that we need to grapple with as a state is trying to find the right balance, right? So that we are respecting parents' right to the care, custody, and control of their children and to raise their children as they see fit, while also balancing that with the state's interest in ensuring that all children are educated and the state's responsibility to ensure that children are protected from abuse and neglect, and the child's right to an education and not to be abused and neglected. And it's sort of trying to find the right balance and to do that in ways that are as non-intrusive as possible, right? And so you sort of raise this question of, well, what if we had a notification process? So whenever there's an open case with DCF, we tell the school, and then we tell the school to notify DCF. I mean, I think that it's a question of how the state wants to weigh all these competing interests, right? If there's a system where parents who have an open case are then that there's a notice to the school district that they have an open case, that's fairly intrusive, right? And some of those are going to be cases where there's an open investigation that becomes unsubstantiated, right? There are lots of investigations. In fact, the vast majority are not substantiated. And so I think that's one of the questions that the state needs to answer is, do we want to notify school districts of everybody who's got an investigation in order to close this loop, or do we want to sort of have this process where the notice goes to DCF and DCF can check if there's an open case? I think that the latter is actually less intrusive. It's more people, but it's less intrusive because it's not sharing information with the public school about what may be an allegation that becomes unsubstantiated. But it's a balance. I mean, these are difficult questions. There isn't an easy answer. And one of the things that we proposed in last year was that there be a requirement that the school system, when they receive a notice that a student is withdrawing, that they look at their own records. And now that's going to be limited. It's only what they know as a school, but that they look at their own records to determine whether the withdrawal does raise questions, right? Because withdrawing your child for homeschooling in and of itself, there's nothing wrong with that. Parents are allowed to do that. And I've said many times, many parents do an amazing job homeschooling their children, right? And the goal here is not to stop them from doing that, but to ensure that kids are safe. And so we recommended that the schools check their own information. Is this a family that we've been reporting to DCF? Is this a child who's been chronically absent that we're concerned about? Have we had concerns? And then if there is reasonable suspicion, then make a report at that point.
But you're changing it up because before it was if they had an open substantiated case. You just mentioned if they've been looked at for you mentioned several things that they may have been checked on for absenteeism or anything else. So you're just simply saying that if a family has been questioned at all by DCF for any of the above reasons you just listed, that would trigger some kind of investigation. But I think that the families out there feel like they haven't done anything wrong, and now you want to take their names and notify. You want that sent as notification to DCF, and that's really unconstitutional. We've never done that. We're going to be setting a precedence of something we've never done before. And honestly, I don't even see how it helps anything. I look at the Mimi case, I look at the Waterbury case, and the Matthew Tirado case, and in none of those cases would that have changed any of it, because you said they would have had to be substantiated cases. That's what we're talking about, is an open case, a substantiated case, correct?
No, open case doesn't mean a substantiated case. An open case is a case, any case where there's an investigation. Sometimes there is not a substantiation, but it's transferred for ongoing services. That would be included. And there are times when there's no substantiation, but there's a court petition. So we're not talking only about, in terms of this open case, it's not just where there's a substantiated case. An open case can mean anything from there's an investigation all the way to up and included a substantiated case where there's court activity.
No, this is even more intrusive than I thought. You're saying that if someone's being investigated, nothing's been substantiated, that report will be given, that notification, just simply because they're being investigated for whatever reason. And that could be closed and it could be shut and nothing came from it. And you're simply saying that that's going to marry the two. That's going to say, okay, this kid got pulled out, and this is an open case, so we're going to now put that it's going to be a trigger in their file, which to me, in my opinion, is even more intrusive than what I initially thought. But I still am landing with, I don't understand how this is going to help in any way with the cases that we're really, really concerned about, because all you're doing is notifying DCF. DCF's going to come back. But now if you're saying it's an open case, we're really opening up a can of worms here. Now, if I understand it right, and I read right, the education commissioner is saying that she's not going to comply with this law or this new policy because it'll break rules with regard to the federal government and FERPA. So I think there's a lot of concern here. I know you didn't put it in, but I know you're advocating for it and supporting it. And I believe that we're now presuming guilt until you're proven innocent. We're saying you could very well be guilty. Let's put your name up on the stake and see if anything you shake out comes. And if it doesn't, well, okay, we'll release you. We don't know where the name's going to go. And quite frankly, I wouldn't trust anything. I would think that the name could stay in there, even if they say it wouldn't, for some trigger along the way. But this is really concerning. I think that we're setting a precedence of sending in notifications for parents that have done nothing, absolutely nothing wrong. And this is going to be a whole new day for the state of Connecticut and DCF. Thank you.
Thank you, Representative, for your comments. Senator Marr for further comments on SB 6, Senate Bill 6.
Sure. So let me just explain why I put this in Senate Bill 6. And the reason is that we know that the young girl who died, Mimi Rodriguez, her mother used homeschooling as a smokescreen when she had bad intent. Well, in fact, we know that she used it as a smokescreen when her daughter was already dead. We are not in any way, shape, or form suggesting that homeschool parents have a plan for bad intent. What we are saying is, in some instances, this kind of thing has happened. So the idea here is, and I think that it came up well in the earlier portion of our public hearing, that we need to include language which explains how the names, after they've been run through a system, are deleted and shredded. So we need to be more clear about that. But what this means is, I completely agree that we do not want to be having DCF sending the names, as the child advocate said. We do not want the DCF sending names of all open cases to schools. That is not the right idea. But when a child, and there are not that many that are being withdrawn from school, many homeschooling parents are already homeschooling. They're not withdrawing their children. But when a child is withdrawn and the name is checked against the record, that means that we know that there is someone who is a mandated reporter, is going to have eyes on a child who already has a case file. That means we know that there is some oversight. The rest of the names just get shredded and thrown away. Okay? We are not keeping names. We are not opening files. We are not doing anything to harm homeschoolers. But what we are trying to do is make sure that when there is an instance where a child is potentially in danger, that there is knowledge of that. So that is why this bill is, because we do not want anyone to use a smokescreen and cast doubt on other homeschoolers by using the homeschooling withdrawal option. So in effect, what it will do is both protect the people who are homeschooling with the best plans in place for their children, and also protect the children whose parent maybe does not have the best plan in place for that child. So that is what we are doing. And it is not to do anything more than make sure that a mandated reporter knows that a child is potentially in danger. So I appreciate the fact that it was brought up about what happens with the names, because that is something we definitely need to fix. And I just want to say, since it is not the child advocate's bill, I wanted to explain it a little bit further. Thank you, Mr. Chair.
Thank you, Madam Chair. I appreciate your comments on that and the clarification. Seeing that there are no other questions, I believe that Representative Dauphinet's hand is up from her previous question. Christina, thank you for your testimony, and we look forward to seeing you very soon. Thank you, ma'am.
Thank you.
We're going to revert back. We see that number 3, the Honorable Jaime Foster, is with us to provide testimony. Representative Foster, you have the floor, ma'am.
Thank you, ladies and gentlemen and distinguished members of the Children's Committee. My name is Jaime Foster, and I am the state representative proudly serving Ellington, East Windsor, and Vernon. I come to you today to testify on one of the committee's big bills to talk about reform in the Department of Children and Families. I am not happy to be spending some time talking to you about this today because unfortunately, when I became a state representative, I was not aware that the natural point of escalation for families in their very worst moments would be to share their most horrifying stories with me. And unlike the Department of Children and Families, where these are folks who have training and experience and are prepared to equip, I have found myself on many occasions very emotionally poorly equipped to handle the things that I have learned and seen. In the last few years, on a couple of occasions, I have had families who live in my district reach out to me after their child has come home from our public school systems significantly injured and harmed. Most recently, in the beginning of the school year, a mom sent me a message, and I opened up the pictures and was horrified to find the injuries on her son's body when he came home from school with no notification from the school that he had been injured or hurt during the day that he was there. Of course, I immediately called DCF and my chief of police. I waited on hold for DCF for over an hour before I was able to file a call. And I called my police chief and was immediately connected with dispatch, and they filed a complaint and they had already begun investigating. Throughout this process, I heard from local law enforcement and school officials and families who had engaged with the system that when the problem is occurring in a school system, DCF is at best poorly equipped to handle the investigation, and at worst, will discover and find things and not have all the tools and resources to be able to move things forward, and sometimes come to what is a false resolution, a culmination of a case where there is no true resolution and answer found for that family. I've talked to a lot of advocates and attorneys in the space on behalf of this family, and you will be hearing from the mother later on today. But I believe that there's a variety of different things that the state of Connecticut can do to prevent such cases from becoming so egregious. The first and most fundamental one is that the people who are investigating school-based issues need to have significant continuity and need to be required to communicate with the families every resource that that family has available to them. This family requested information from DCF and was given a one-page summary of DCF's investigation. They did not realize that there was special terminology that they needed to use to ask for the full report. There should not be special lingo required of a family in their worst moments to get the most details that they need to make sure their child is safe moving forward. Additionally, right now, our DCF investigators are significantly hamstrung. They have to focus on identification of a perpetrator, but they're investigating situations in school where they could be identifying systematic barriers that resulted in the possibility for that child being abused and neglected in the school system. And so I believe statute should be amended to require the Department of Children and Families to make findings in the following: whether the child was in fact abused or neglected, if a perpetrator is identifiable and can be existed, and any other actions that should be taken by the school to remediate the case to ensure that that child is safe moving forward. It should be the responsibility of the Department of Children and Families in these investigations of schools, not just to identify a perpetrator, but also to make sure that steps to remediate the risk that occurred that allowed a child to be harmed are prevented in the future. There should also be required follow-up. Right now, when abuse or neglect occurs in a licensed facility, for example, a residential program or a childcare program or a DDS center, the licensing authority might be required to take corrective action. But in public schools, there's a regulatory gap. There appears to be no requirement of DCF to investigate reports showing employees, and that those are then forwarded to the State Department of Education. And there's no clarity in whether or not there was reasonable suspicion that a specific faculty member was involved in the harm of a student and that protective action is being taken moving forward. That same statute exists in OEC settings where they're being notified of suspicion of abuse or neglect with the same threshold of investigation. That is not currently happening in our public school systems, and I believe it is an unintentional gray area. Finally, in both of the situations that I have seen in my school, one where a child who was wheelchair bound and nonverbal was significantly harmed, likely at the hands of staff, and another situation where a child was significantly harmed when inappropriate staffing was maintained, and another child who had plans to harm that child was able to gain access to that child, those children with disabilities, they're particularly vulnerable in school settings. If a school district has repeated findings of abuse or neglect, DCF should be required to work with the Office of the Child Advocate and the Disability Rights Community or Disability Rights Connecticut to build upon existing requirements of that school to remediate and make recommendations for statute to prevent similar harms. Lastly, it seems clear to me that the staff that are investigating these school-based crimes are sort of set up against a regulatory framework that outbalances them. Schools are increasingly legally focused. They're focused on providing the services required under the law to the exact letter of the law. And it is significantly different than investigating a home-based incident. And so I ask this committee to consider ways that they can bolster and strengthen the ability of the Department of Children and Families to investigate allegations of abuse and neglect that occur in the school. There are a variety of different types of abuse and neglect that may be a risk in a school system, and there should be specific staff within DCF trained to handle each separate encounter. For example, specialized investigators focusing on physical neglect or abuse that happens during the school day, specific staffs trained on investigating unexplained injuries and improper use of restraint and seclusion. And lastly, it should be specific training and staffing required to look into sexual grooming, abuse, and sexual exploitation of minors. Unfortunately, I have come to learn that there are, in fact, cases where children are harmed in the school setting. And I know it's this committee's goal to make sure children are kept safe in every way that's possible. And it is clear to me the Department of Children and Families not only needs better resources, but perhaps better authorities to follow up and investigate these crimes. I am unable to overlook that in the conversations that I've heard in this discussion so far, there are many times where we are discussing cases where DCF ran up until the end of their statutory authority. And then in the aftermath, we found that what a child experienced was egregious and horrifying. And within the system, DCF may or may not have been able to fully exercise every authority that was available to them. I don't want to hear stories like this anymore as a legislator. I want to give DCF every resource and authority that they need to make sure children are safe in our communities. And I hope that this committee will support making those recommendations, and I'll be sharing them to the committee leadership in writing. Thank you.
Thank you, Representative Foster. We appreciate your testimony. Are there any questions? Seeing that there, Senator Marr.
I apologize. I just have one really quick question, which is, was there resolution at the end? Was DCF able to get the files to the family? Did the family feel like they had heard what they needed to hear? What was the resolution on this pretty horrible
Well, Kate
thing?
Anderson will be speaking before you later on today, and so you can ask her that same question. But in what I have heard in the situation so far is that they asked for a report of the investigation, and they were given the one-page summary, not the full report and the full details. And they did not realize that that was a specific request that needed to be made separately. And as a legislator, I didn't know that that was something they needed to specify differently either. Now they're in the 90-day wait period while they're waiting to find out the results of the investigation. But in the meantime, that child's expected to go back to school.
Thank you.
Thank you, Senator. Thank you, Representative. We appreciate your attention to this matter. Next on our list, we have Sarah Egan. Sarah?
Good afternoon to the committee, Senator Marr, Representative Paris, Senator Perillo, Representative Daphne, all members of the Children's Committee. This testimony, I'm testifying on behalf of the Center for Children's Advocacy. I am the Executive Director of CCA, and we are a statewide legal rights organization dedicated to the individual and systemic legal advocacy on behalf of children statewide in Connecticut. I know we've had a late day, so I'm going to go quick. I'm not going to read off my many pages of testimony that I've provided, though I'm happy to answer questions about any of it. One, I wanted to thank the committee for raising several bills that have to do with creating greater transparency and accountability for how we are serving children in the child welfare system. I want to be clear, and I know you've heard this from me before, everyone in the system is working as hard as they can, wants to have a good impact, wants good things to happen for children. But I also want to be really clear that in my view, the system is not working the way it needs to for kids. Right now, CCA represents probably between 50 and 60 children statewide, from Hartford to Bridgeport, involved in the child welfare system. And the things that we see across our cases and that we see echoed in these state and federal audits are telling us that we really have problems in every aspect of the system. That is not to say good things don't happen. Good things happen every single day. But every day we have children struggling to find appropriate foster care. We have kids on our caseload who have moved through multiple placements, very young children. We have kids as young as 13 living in state licensed shelters and often running from those shelters because their needs aren't being met. And we have, frankly, multiple workers and supervisors from DCF who, over the course of time, I don't want to be too specific, but say to us, they don't have what they need for our kids. I mean, some have said directly to us for our teenagers, some who are subject to orders of the court to come into DCF care, they've said, we don't have anything for him. So that tells us that we have a problem, not a problem of effort or intent, but a problem of process, a problem of infrastructure, and a problem of outcome. And so I appreciate the comments that we've heard from everyone today. I think what we have to think about, one, is DCF's work is incredibly complicated, right? Often for in ways that they can't predict, right? The opioid crisis, COVID, like God knows what comes next, right? But a lot of things we can predict. Constant need for alternative caregivers, a constant need for family preservation services, a constant need to support older youth exiting care, a constant need to make sure we have a state contracted and Medicaid funded system of care that works, right? So what is the infrastructure needed to support that system in a durable and dynamic way that is both reactive, but also preventative and responsive? So the bill itself today, 5004, which is really what I'm testifying about, I think has a lot of really good components, right? Tackling increased care, increased support for foster parents. Obviously, we want to make that as across the board as we can, helping kids aging out, finish their education, increasing training for people in foster care, training for people working with kids in foster care, and creating a meaningful oversight structure, right? All of that, I think, are steps in the right direction. I'm sure there are technical changes that can maximize the impact of those provisions. CCA is always happy to continue to work with the committee and the drafters in any way. We did include in our testimony that I wanted to flag some additional thoughts and recommendations along the items that you've raised, but frankly, some additional items. I think one of the biggest things we do have to tackle is the state and federally funded system of care that we have for kids. I think one of the biggest challenges DCF has is they are not able to connect children and families to the services that they need in a timely fashion. And that, that is a little bit, there's a lot that's unpredictable about child welfare. I'll just be candid that I think that that's a little bit our chickens coming home to roost, because that's been brewing for so long. There's a lot of great effort looking at that right now, but until we get that service system more robust, I think we're going to continue to have some struggles. That doesn't mean there aren't very specific things that we can do, even in a short session, to move this ball down the field. I'm very grateful to the committee for this comprehensive effort to do that in a few of the bills that you've raised today. And I think I've said everything in my notes, so I'll pause, and I'm happy to answer any questions or be of help in any way. Thank you very much.
Thank you, Sarah. I appreciate your testimony and certainly your insight around this issue. Are there any questions for Sarah? Comments? Seeing none. Thank you, ma'am. I appreciate it.
Thank you.
Next up, we have Sarah Lockery. And by the time we finish with Sarah Lockery, the good vice chair of this committee, Mary Wielander, will take over in chairing for the next hour. Thank you.
Hello, Senator Mayer, Representative Paris, Senator Perillo, Representative Daphne, and members of the committee. I'm here to talk about House Bill 5004. I co-chair the DCF Statewide Advisory Committee, and I also work as the Chief Operating Officer at the Children's Center in Hamden, where we provide a continuum of care. And I've worked there for 35 years, so I've been around for a bit. And I want to thank you for recognizing that our behavioral health and child welfare systems need some oversight. I, however, am concerned that the Oversight Council being proposed might not achieve the outcomes that folks are seeking. And I say that because our state truly is in crisis. And I believe there are 4 contributing factors that have landed us where we are now. And if we address them, we really do have the potential to create sustainable improvements for our kids. One is, as Sarah Egan was saying, our behavioral health system is grossly underfunded. We just had to, we were interviewing a person for a social work position at the Children's Center, and we couldn't offer her the position because she asked for $20,000 more than what we were able to afford. And her request, although it seemed extreme, was very reasonable for a licensed clinical social worker. I also, at a recent SAC meeting, had representatives from our various councils attend, as well as folks with lived experience, both kids who have been kiddos in the foster care system, as well as family members. And all were very clear with the department that we need more funding for behavioral health. A second factor is that, Connecticut has reduced congregate care beds like many states have in our nation. And that was with good intent, because we all believe children need to grow up in families. But it's not good for kids to bounce from foster home to foster home. And I heard of one situation where a 6-year-old child had 5 foster placements. That was not the intent when we dismantled our congregate care beds, again with good intent, but Connecticut failed to create a safety net for those kids. So we need to really invest in our community structure. Third is a big one, and I think that having DCF responsible for child protection services and behavioral health is way too big of a mandate for one state agency. And I think we really need to take a look at if that's something that we want to continue. And the fourth is we do not fund or we do not resource our citizen review panels in Connecticut. We receive funding from the Child Abuse Prevention and Treatment Act, and we're required to have 3 citizen review panels. And I think those panels will achieve the outcomes that you want. A panel is required to evaluate state child welfare, make recommendations for improvement, and to submit an annual report with recommendations. And I know this because the SAC is one of those CRPs, but our hands are tied and we're not able to do what a CRP can truly be able to do. And I'd be more than happy to provide you with more written information about the CRP so that you can consider that when you're thinking about oversight for the department.
Thank you, ma'am, for your service to our state and to the child welfare system. And we appreciate your comments. Are there any questions for Sarah? Representative Comey and Representative Wielander.
Okay. Hello, Sarah. Thank you so much. Good to see you.
Good to see you too.
So I was furiously writing because I know you are such you have such a huge bed of knowledge about our kids that are in care, under our care. So your number 3 that you said, could you please talk about, you said DCF and something else? Yeah, thank you.
Yeah, sure. So right now, DCF's mandate is to oversee both the behavioral health system and the child protection system for kids. And those are two huge mandates. And I really think it's too much for one state agency to do.
Thank you.
Yeah.
And I've been to your SAC meetings and not in quite a few years, but I know you have all the players at the table there. And so you're telling us that is the citizen review board or the panel, and you said that do you not have the resources? Is that why that work's not happening there? Can you elaborate?
Sure. Yeah, so my understanding is that because of the amount of funding that Connecticut receives from CAPTA, we're required to have 3 citizen review panels. The SAC is one of those panels. We are not, however, empowered to really do what is charged to say a citizen review panel. So a citizen review panel should be able to have the authority to go in and look at DCF records, to have the resources to have somebody go in and do an evaluation, to really do the oversight that folks are saying, and rightfully so, that the department needs. So I mention it because I think that we have something in the state that if we really learned more about how we can use them effectively, can be a huge addition to our child welfare system.
Okay, thank you.
Sure.
All right, see you around. Thanks, Sarah.
Thank you, Representative. Representative Welander, followed by a question that I have after. Thank you.
Thank you, Mr. Chair. And Sarah, thank you for your testimony. Did you submit written testimony?
I did.
Okay, perfect. Just want to make sure I can go back and refer to it. And if you are able to also share some more information about the SAC versus CRP and what constructive next steps might be taken, that would be greatly appreciated.
Absolutely.
Awesome. Thank you so much. Thank you, Mr. Chair.
Thank you, ma'am. If I have a question, Sarah, related to SAC, and I guess the question is for all of us to better understand, if SAC is sufficient, what enforcement mechanism exists when DCF does not implement the recommendations that SAC makes?
Right now, there is none. So we make the recommendations, and my understanding based on the CRP language is that the department needs to respond to us within 6 months. But the yes or the no about what they do, like it's just a response to what we recommend.
Okay, and I'm trying to figure out how to ask this without making it 2 extra questions and trying to get it into one here. So if you're not getting any updated, if your recommendations are not being implemented, would you say that because of the recommendations that you might make within SAC, do you think that it would strengthen the child welfare system? And because those recommendations are not implemented, we are further behind the mark in terms of where we should be within the child welfare system?
Either both child welfare and behavioral health. What I've seen is that there have been recommendations from various bodies that keep coming up year to year to year. Like I think about the Children's Behavioral Health Implementation Advisory Board. I know the Transforming Children's Behavioral Policy Committee. Like there's some things, CHDI about workforce. So there's some things that seem to be repetitive through the years.
I certainly agree with the repetition or the repetitive nature of many of these convenings. And I don't disagree with you on that. I think, however, what we have seen is that since there has been oversight with regards to juvenile justice, that juvenile justice has politically and legislatively in our state grown by leaps and bounds, has become a lot stronger. The same with TCB, arguably, which is a model for the rest of the country to follow. I don't want to, and I would even argue with now the endowment on early childhood education, which is, one of the only of its kind throughout our country. It does not negate the work that's being done by many other additional advisory groups, but I think it adds to it because it holds a level of accountability and transparency on the issues that we're trying to get done. So I appreciate your comments and you just clarifying that there's not very much that is actually implemented. And I do hope that Section 20 of this bill, which recommends an oversight committee, will be able to rectify many of those things. Thank you, ma'am. Madam Chair.
Thank you. And seeing no other questions, Sarah, you were all set. Thank you.
I'm sorry. I'm sorry, Representative
Yeah,
Leander.
yeah,
I
go
had
ahead.
a second question or a third question, actually.
Is Sarah still here? Perfect. Great. Go ahead.
Okay, thank you. I appreciate it. The oversight overseeing the behavioral health and the child protection system, have you had a thought on whom might be similarly poised to handle, say, the behavioral health piece?
I do not.
Okay, thank you. All
Thank
set.
you.
Sure, thank you.
You're welcome. No problem. Thank you. All right, we are going to be moving on. We are up to speaker number 8, C. Marcella Karowski, followed by Alicia Davis, Emmeline Franklin, and Katherine Marcato. Just as a reminder, we have, if you're in the waiting room, you need to accept the invitation to become a panelist, and before you can do your 3 minutes of testimony. Thanks so much. Marcella, go right ahead.
Members of the committee, I'm Marcella Karowski. Thank you for the opportunity to speak today. I oppose Section 5 of SB 6. This is legislative creep and quite possibly a placeholder bill. Parents have the authority over their children. They are responsible for their well-being and their education. A century after women's suffrage, we are a children's voice until they are of age to vote themselves. I find it interesting that women's rights have the support from the majority of the legislature when she chooses not to be a mother. Now the majority of the legislature can vote to dismantle a woman's rights after she is already a mother. I find it offensive that for years, there are bills in which a state wants to override the decision-making of parents for their children. My children are gifts from God, and I conceived, gestated, birthed, and nursed them. Not one government official or employee is more invested in them than I am. And each lawful citizen has a right to be safe and secure in their persons, papers, and homes. Thank you for your time, and God bless you all.
Thank you so much for your testimony. Seeing no questions, you are free to go.
Thank you, Representative Waylander.
You're welcome. All right, next moving on is Alicia Davis. Are you with us just yet? Looks like not. We have a change in the list. Number 11, Katherine Marcato. I think you're here. Oh, there you are. All right, go right ahead.
Hi, good afternoon, members of the Children's Committee. My name is Katherine Marcato, and I'm speaking in opposition of Section 5 of Committee Bill SB 6. As I begin my testimony, I think it's important to know where my perspective comes from. I am a Connecticut resident, a homeschooled graduate who went on to obtain a bachelor's and master's degree. I am a pastor at a Connecticut church, and my husband is a Connecticut educator. I am a foster parent who has been licensed for 9 years and has had more than 100 children come through the doors of my home, needing safety and care. I say all of this because I want you to understand that I take protecting vulnerable children seriously. I understand the vital role that DCF has, and I know my role as a mandated reporter. However, Section 5 of SB 6 creates a system that treats families who choose alternative schooling options, including homeschooling, as an inherent risk category, and I do not believe that's appropriate, necessary, or consistent with the rights of parents. Parents have a fundamental right to direct the upbringing of their children. This includes education. Families choose to homeschool for many legitimate reasons: academic needs, medical concerns, religious convictions, the safety of their children, or because a child is being bullied or struggling in school. These are not red flags. These are responsible parenting decisions. It's also important to note that school employees are already mandated reporters. If a school has a genuine good faith concern that a child is being abused or neglected, they're legally required to report those concerns to DCF. That safeguard already exists. Furthermore, if the school has concerns that a child is being removed because abuse and neglect is occurring, that would constitute a reasonable and good faith report. There's no need to create a blanket referral system that captures every family that wishes to homeschool or send their child to private school. I am acutely aware of the importance of accurate and responsible reporting. Referring families to DCF without individualized suspicion risks undermining the integrity of the reporting system itself. DCF's own policies are clear that reports must be made in good faith and based on reasonable suspicion of abuse and neglect. Creating a mechanism that automatically routes families into DCF's awareness without such a suspicion contradicts the spirit of those standards. Beyond that, this provision intrudes on families' privacy without cause. It expands state tracking of families who have done nothing more than exercise a lawful education choice. That kind of surveillance erodes trust between families and schools and diverts very limited DCF resources away from children who are truly at risk. Child protection is essential, but effective child protection depends on targeted and evidence-based intervention, not broad policies that treat lawful parenting decisions as potential danger signs. There's no other area in which we report parents to DCF for making decisions regarding their children, and for good reason. We don't assume that parents will abuse and neglect their children when they take their babies home from the hospital, and we shouldn't do so here. If there are concerns, mandated reporters and the public who is welcome to report should report those concerns, but creating the blanket referral system is not the answer. So I respectfully urge you to reject Section 5. Homeschooling should not be a presumed risk factor for families who are acting in good faith to educate their children. I thank you for your time, and I would welcome any questions.
Thank you, Katherine, for your testimony. And thank you for being a foster parent. It's
Thank
something
you.
that we desperately need more of in the state. And
We
if you
do.
have any, thank you. No, seriously, if you have any suggestions on what we can do to start looking at supporting that process and potentially, encouraging more families to take on that role at
Sure.
certain points in their life, that would be greatly appreciated.
Sure.
Thank you. Seeing no other questions and comments, you are free to go. Thank you so
Thank you.
much. All right, up next, Catherine Farnsworth, I don't see online. Next is number 13, Ruchi Sheth, followed by Emily Knox, Jessica Vargas, and Corey Warl. These are numbers 13 through 17.
Hi, I'm sorry. I'm having some tech issues and my camera won't start. But if it's okay, I can proceed with my testimony.
I believe that's okay for testifying.
Okay. Again, my apologies. Good evening, co-chairs Mar and Paris, vice chairs Cohen and Wieslander, ranking members Perillo and Dauphiné, and esteemed members of the committee. My name is Ruchi Sheth, and I'm a research and policy associate at Connecticut Voices for Children, a research and advocacy organization working to ensure that one day Connecticut is a thriving and equitable state where all children reach their full potential. Connecticut Voices has submitted testimony on a array of bills on the agenda, but today I'm testifying in support of SB 6, an act concerning supports for children and families. For the sake of time, I will focus on sections 1 and 2 of the bill. However, we have submitted more extensive testimony for your review. Section 1 proposes a fully refundable $600 child tax credit effective January 1, 2026 for up to 3 children, with a 10% reduction for every $1,000 that the taxpayer's federal adjusted gross income exceeds the following thresholds: $100,000 for single filers or married individuals filing separately, $160,000 for heads of households, and $200,000 for married couples filing jointly or surviving spouses. Connecticut Voices supports the proposal for the Connecticut Child Tax Credit for the following reasons. Establishing a Connecticut Child Tax Credit would provide needed, well-targeted financial support, especially for Connecticut's lowest income and middle income households with children, two groups who receive little to no support from the Connecticut Earned Income Tax Credit. In 2024, prior to the new federal cuts, nearly 65% of Connecticut's residents experienced some level of difficulty paying usual household expenses, and 15.8% reported that it was very difficult. For adults with children, the rates were even higher due to the high cost of raising children. Establishing a Connecticut child tax credit would make Connecticut's tax system fairer and more aligned with other states. Connecticut's tax system places an unfair burden on low and middle income households, making it harder for them to make ends meet. The state's tax system also places an unfair burden on many households with children compared to households without children. As we show in our written testimony, based on a 50-state analysis of tax systems in 2025, Connecticut is one of only 4 states with a broad-based personal income tax that does not adjust for the number of children or childcare expenses, and the only high cost of living state that does not adjust for children. Establishing a Connecticut child tax credit would align the state with national norms and make the tax code fairer for families raising children. Section 2 would establish universal free school meals beginning in fiscal year 2027 for eligible districts not participating in the federal community eligibility provision and make those districts eligible for state grants. Connecticut Voices supports this provision because food insecurity remains a serious and growing challenge in Connecticut, affecting approximately 1 in 6 children since the COVID-19 pandemic. Hunger undermines a children's concentration, memory, mood regulation, and overall academic success, and universal free meals both reduce stigma and help families stretch limited household budgets, even for those not currently food insecure. Food assistance programs like school meals and more importantly, SNAP, are proven anti-poverty tools. In 2022 alone, they lifted more than 50,000 Connecticut residents out of poverty, including 9,060 residents through the school lunch program, 5,710 of them children. With federal SNAP and Medicaid work requirements potentially reducing access to school meal eligibility through direct certification, state-level action is even more critical to ensure consistent nutritional support. Investing in universal school meals is an investment in children's health, educational outcomes, and future of our state. In closing, we thank the Committee on Children again for your leadership and service. Your collective commitment to providers, educators, families, and children across our state is what has and will continue to make a difference. And with that, I'm happy to take any questions.
Thank you so much for your testimony. Seeing none, you are free for the rest of your evening. Thank you so much. Next, Emily Knox, followed by Jessica Vargas, Corey Warl, and Diana Bump.
Yes, I'm here. I don't think my video is loading for whatever reason.
Madam Chair, if I might, I think, Emily, there's a screen protector over your camera. That might be it.
There isn't. There's nothing over my camera. I guess I will turn it off and proceed anyway. My apologies. Good evening, Senator Marr, Representative Paris, Senator Cohen, Representative Wieslander, Senator Perillo, Representative Daphne, and esteemed members of the Committee on Children. My name is Dr. Emily Knox, Research and Policy Director at Connecticut Voices for Children. CT Voices submits verbal and more extensive written testimony in support of HB 5380, an act concerning the Office of the Child Advocate, and HB 5004, an act concerning child welfare accountability and transparency. However, I want to focus my remarks today on one provision that is foundational to long-term stability for young people: post-secondary education supports for youth with foster care experience, as outlined in Section 10 of HB 5004. Education is not simply an academic milestone. It is a protective factor. It's an economic stabilizer, and for young people with foster care experience, it is one of the clearest pathways to long-term independence. The research is remarkably consistent. Youth who experience foster care graduate high school at lower rates than their peers. They enroll in college at lower rates, and they complete degrees at dramatically lower rates. Nationally, while roughly half of young adults complete a 2 or 4 year degree, only about 8 to 12% of youth with foster care experience earn a credential by their mid to late 20s. That's not a small gap, that is a structural gap. And importantly, it's not a gap driven by lack of ambition. Study after study shows that young people in foster care overwhelmingly want to go to college. They have the aspiration. What they often lack is the stability. They're navigating housing insecurity, food insecurity, trauma exposure, school mobility, and the absence of the family safety net that most young adults rely on during college. The place to go during breaks, the emergency financial help, the co-signed lease, and the quiet support that allows a student to focus on school. HB 5004 takes an important step by codifying post-secondary grant support and allowing continuation through age 23, and that matters. Formalizing the program provides predictability and accountability, but we also need to align policy with reality. Even among the general student population, only 44% of students complete a bachelor's degree within 4 years. Most students take longer, and timelines are longer still for first-generation students, for students who work substantial hours, and for students navigating housing instability, characteristics disproportionately represented among youth with foster care experience. If we know completion takes time, policy should reflect that. Extending eligibility, as proposed in HB 5270, to allow program entry through age 26 and completion through age 28 better reflects contemporary educational timelines. It recognizes that resilience does not operate on a rigid clock. And the return on investment is clear. Post-secondary credentials are associated with higher lifetime earnings, improved health outcomes, greater employment stability, and reduced reliance on public systems. For youth who have already experienced state custody, supporting degree completion is not just an educational strategy, it's a long-term fiscal strategy. We cannot change the adversity many of these young people have already faced, but we can change the structure of opportunity in front of them. Education is stability, mobility, and prevention. I respectfully urge the committee to strengthen and support these bills. Thank you for allowing me to testify, and I'm happy to take any questions.
Thank you so much. I really appreciate you being here today and for mentioning the timeline that is often a little bit longer when you don't have the foundation of stability that some children have. But seeing no other questions or comments, we are all set. Thank you so much.
Thank you.
And up next, Jessica Vargas.
Might be having the same issue.
Ooh, I wonder then. Oh,
no.
wait, nope. All right, there we go. Go right ahead, ma'am. Thank you.
Hello, everyone, and thank you to the Committee of Children for hearing my testimony today. My name is Jessica Vargas, and I am a resident of New Britain. I'm here today to urge you to support funding to provide free breakfast and lunch to all students in schools that participate in the National School Program, as highlighted in Section 2 of Senate Bill 6. Although my children are older now, I clearly remember how stressful it was to manage the cost of school meals. Every year during that first week of school, parents would receive that large packet of paperwork, which includes, the lunch forms. And that lunch form application determined whether their child qualified for free, reduced price, or paid meals. As a child myself receiving a free lunch, I always felt different, especially after I noticed that other kids who didn't get free lunch had more options. At that age, I didn't understand income thresholds or policy decisions. I only understood that I was poor and they were not. Years later, as a working single mother earning $17 an hour with 2 school-age children, I found myself just above the eligibility cutoff. Even at a reduced rate, paying maybe $4 to $5 for breakfast and lunch for both my kids, that added up to be about $25 to $30 a week. For family living paycheck to paycheck, that is not a small amount. That is groceries, that is gas, that is a utility bill that may or may not get paid at that time. I remember wondering who decided that $17 an hour with 2 children meant that we didn't need any help, because I clearly did. I was working full time, doing everything I was supposed to do and still struggling to keep up. When my children later transferred to magnet schools in Hartford, I was relieved to learn that meals were provided at no cost to families. That extra $25, $30 a week made a real difference in my life. It meant that I could buy my kids an extra pair of shoes during the school year. It allowed me to enroll them in extracurricular activities. I think it was baseball at the time. But that small amount, which may be small to some, is really significant to many. It really created an opportunity for my family. Eventually, I was able to make it work, but far too many families cannot. As a network representative at Connecticut Food Share, where I currently work, I work side by side with partner agencies to support those in need. I'm also a newly elected alderwoman in New Britain, and I'm seeing firsthand, day in and day out, the real struggles that families are facing when it comes to putting food on the table. We have to ask ourselves what good comes from denying a child a meal or burdening families with a meal debt. Why should any student feel singled out simply because of their family's financial situation? And most importantly, how can we expect children to learn, to thrive, and to reach their potential on an empty stomach? Providing universal school meals is not a compassionate policy, it's a smart policy. It supports academic performance, it reduces stigma, and it provides stability for working families. At the very least, we can at least ensure that while children are in school, that they are at least fed. I urge you to support this funding and invest in our students, our families, and our future. And I thank you for your time, and I'm open to any questions.
Thank you so much, Jessica, for being here and for really highlighting the real world implications of providing this kind of support and how it really can make a huge difference over time, especially. But I am seeing no other questions and comments. Thank you. We appreciate your time tonight.
Thank you. Good night.
Up next, number 17, Corey Warl, and I apologize if I'm not pronouncing your last name correctly.
No, you got it.
Awesome. Go ahead.
Chair Paris, Chair Marr, and members of the committee, thank you for having me today. My name is Corey Warl. I'm a state policy analyst at the Prenatal to 3 Policy Impact Center. I'm here today to speak on the research and impacts of a state child tax credit here in Connecticut as proposed in SB 6. The Prenatal to 3 Policy Impact Center is a nonpartisan research center based in Vanderbilt University. We focus on identifying state policies that have been proven effective by rigorous research with an emphasis on policies that help children and families thrive in the earliest years of life. We do not take official positions on any legislation, and our testimony reflects the research on a given topic rather than the views of the university. State child tax credits, or CTCs, are designed to help improve families' economic security and reduce child poverty by offsetting some of the costs of raising children. Policy progress on state CTCs has been rapid in the past few years, following the expansion of the federal child tax credit in 2021, a policy choice that ultimately lifted 2.1 million children out of poverty. Currently, 16 states offer a state-level CTC, more than half of which were implemented in the past 5 years. Because of this recent growth, research has not quite caught up to state progress. However, preliminary research shows that state CTCs are a promising policy to improve child and family outcomes. Research and simulation studies have found several benefits, including reducing child poverty, increasing children's resources, and decreasing reports of child maltreatment. Importantly, state CTCs have not been found to harm labor force participation. By increasing household resources without impacting employment, state CTCs can improve financial stability for families and allow parents to better meet their children's basic needs. States can make different policy design choices around the refundability, structure, and value of the credits, in addition to who is eligible. Though most states structure their credit as a per-child credit, which decreases in value as family income exceeds a specific threshold. As of February 2026, the values of state CTCs vary widely, ranging from $100 per child in Arizona to $1,750 per child in Minnesota. Neighboring states, including Maine, Massachusetts, New Jersey, New York, and Vermont, have implemented refundable child tax credits for families. A state CTC will give Connecticut the opportunity to enhance its tax policy and provide more resources to families. For a parent of an infant, a $600 refundable state CTC, as proposed in SB 6, could have a significant impact on family economic stability, providing funds that would cover 6 months of diapers, 6 weeks of groceries, or 7 months of baby clothes. Thank you for the opportunity to provide informational testimony on state child tax credits this afternoon.
Thank you so much for the your testimony and the information you shared. I had no idea that, was it Montana you said that was so high?
Minnesota, yeah.
Minnesota. There we go. That's good to know. Thank you so much. Seeing no other questions or comments, you are free for the evening. Thank you. Up next, we have Diana Bump, followed, who is number 18, followed by Amanda Medling, Daniela Cruz, and Ashley Hutchkins at number 21. All right, Diana, go right ahead. Thank you.
Hi. I'll be really brief. The part of Senate Bill 6 that I oppose is Section 5. And as I just read from the Commissioner of the State Department of Education in her testimony, it violates FERPA and really can't be implemented anyway. But I think that firstly, this should be a separate bill and not lumped in with other popular, unrelated concepts like tax credits and free breakfasts. I don't think it's fair to this process. And second, I think it's wrong to profile all families who make lawful choices for their child's education outside of public schools. And third, I have concerns about other state departments collecting data on families who are exiting public schools and what that data might be used for in the future. It's an invasion of privacy. Legislation targeting this concern, I think, should find a way to keep reporting of withdrawals to cases that have protective services or supervision in place. And actually, most school districts are aware of families having DCF involvement and do, in fact, report withdrawals. The issue is that the Child Welfare Department has had a history of poor follow-up. Any new legislation should be targeting the root cause of the issue without involving innocent families or creating unnecessary administrative burdens for two state departments. Most families by far who withdraw are simply moving to a new district, entering a private or parochial school, or choosing to educate at home and have no DCF involvement. So I would just ask that you remove Section 5 of this bill and address this concern more comprehensively, fairly, and legally in a separate bill. Thank you.
Thank you. Looks, we have a question from Representative Daphne.
Thank you, Representative Wielander. And hi, Diana. I've heard you testify before. Thank you. I know that or you had homeschooled in the past. I don't know if you still are, but I know that you know many in that community. Can you just speak to how that would make them feel that their name is going into kind of like a register that's going to be notified to SDE and then DCF, merely that they're just doing something that's lawful and legal? Can you just speak to how those people are? I'm sure you've talked to many of them, how they're feeling right now.
Yeah, I think there's a lot of frustration because for those in our community who have withdrawn their kids from public schools, a lot of times they withdrew because the public schools were not meeting their needs. Maybe there was a safety issue like bullying that wasn't getting addressed. If their child had special needs, the schools really weren't meeting those needs adequately. And so they really didn't leave public school on the happiest of terms, and to feel like they are under a microscope for doing what's best for their kids and possibly being tracked. I mean, it's scary, I think, for a lot of parents in our community, but not even just in our community. We're talking about anybody who withdraws from school. So that could be, just people who are moving to a new town or moving out of state, or even just finally being able to afford a private school. And that kind of thing just really rocks people's nerves.
Thank you. Thank you for being here to testify today and speak on the behalf of the homeschoolers. I appreciate it.
You're welcome.
Thank you, Madam Chair.
Thank you, Representative. Seeing no other questions or comments, thank you, Diana, for being with us tonight.
Thank you.
Up next is Amanda Medling. I believe, am I saying your last name correctly? Hopefully.
Yes.
Awesome.
Can you see me?
We cannot. I wonder what's going on.
Hold on. I'm sorry.
There you are.
I think it should
Awesome.
work now. Hi. Okay. Perfect.
Go right ahead, ma'am.
So good afternoon, everybody, or good evening now, I should say. I come before you to give some personal examples of why I believe that Section 5 of SB 6 should be removed. I happen to co-parent very well with my two oldest children's father. He lives in another town than I do, and the children currently reside with and attend schools in my town. We have always made both of our houses home for them. And if this section of the bill were passed, my family, I fear, could be flagged for DCF simply for my children wanting to live at and attend schools at their father's house instead of mine. On another instance, on October 2nd, 2024, the parents of Doolittle Elementary School in Cheshire were notified via email that the school was part of a cyber attack and was in a secure campus mode. As parents, we were not to visit the school, nor could any child be dismissed at the time, and my heart froze. A secure campus mode is different from a lockdown in that with a lockdown, instruction does still take place. Therefore, the children were completely aware and petrified. My youngest still remembers it vividly and cannot experience a lockdown drill without nearly having a panic attack. Thankfully, it was resolved, and I got both of my boys home that day. But I needed them to know that they were safe, and school no longer felt that for them. So we chose to homeschool the rest of that year. They are both very interested in attending technical high school, and therefore I re-enrolled them both into public school system and to try to better their odds at getting into the school that they wish. If this bill were passed, our family, I fear, also would be flagged for DCF for choosing safety and well-being first. I would be lying that if I told you that that year didn't make me fall in love with homeschooling. You literally create your child's own IEP. Getting to watch my kids flourish in each subject that's perfectly tailored to their learning style is absolutely beautiful to see. And being their teacher, I don't have to miss any of those milestones that I used to when they were in public school. I fell in love with it so much that we are homeschooling our youngest two children. We are active members of our church. We attend sports activities and lessons weekly. We are part of a Girl Scout troop and provide many services to our local communities. The activities that we are enrolled in have us around mandated reporters on the weekly basis, if not daily basis. The active cases that I feel are being used against this whole bill, both had open cases with DCF, and we see how they turned out. And sadly, one of the child is no longer Earthside. We do not need DCF oversight for wanting better for our kids. We are asking that you please remove Section 5 from SB 6. And that is it.
Thank you, Amanda, for your testimony tonight and sharing that perspective. So, and good luck with cookie delivery. I know that's happening
Thank
soon
you.
with our so,
Yes.
Representative Daphne, did you have a question? Or is your hand up from last time? I think you're all set.
Okay, thank you.
Okay, thank you, Amanda. Moving on, number 20, Daniela Cruz, followed by Ashley Hutchins and Marissa Bohuniaak.
Yes, hello.
Go right ahead, ma'am.
Okay. Can you see me? Is there a video?
There's not a video.
Let me see. Okay. Hi.
There we go. Awesome. Go right
Okay.
ahead.
Okay. All right. So, dear Senator and representative members of the Children Committee, my name is Daniela Cruz, and I'm a resident of New Milford, Connecticut. I'm writing in strong support of HB 5004, Section 6, 7, 8, 9, 14, 20, 22, and 23. an act concerning child welfare accountability and transparency. This legislation represents an important step towards strengthening oversight, improving transparency, and ensuring that decisions affecting children and families are made lawfully, ethically, and with proper review. The United States Constitution guarantees due process protections under the 14th Amendment, prohibiting any state from depriving any person of life, liberty, or property without due process of law. The right to family integrity and parental rights has been recognized as a fundamental liberty interest. Article 1st of the Connecticut Constitution further protects due process and equal protection rights under state law, requiring lawful authority, documented findings, and meaningful opportunity to be heard before government interference in family life. This testimony also aligns with internationally recognized human rights principles, including the Universal Declaration of Human Rights, Article 12 and 16, protecting family integrity and freedom from arbitrary interference with family life. International Covenant on Civil and Political Rights, Article 17 and 23, safeguarding the family as the natural and fundamental group unit of society and protecting against unlawful interference. The Convention on the Rights of Child, Articles 9 and 16, emphasizes that children should not be separated from their parents except when necessary for the child's best interests and through lawful, reviewable procedures. When the state intervenes in family life, the consequences can be profound and permanent. Policies governing child welfare must prioritize due process, documentation, supervisory oversight, and accountability mechanisms that reduce error and prevent unnecessary harm. HB 504 reinforces public trust by strengthening transparency requirements and clarifying standards for decision-making. Accountability structures protect families while also supporting ethical caseworkers and administrators who serve children responsibly.
Daniela, could you please summarize, Daniela?
Yes. What question?
Conclude, if you could conclude your testimony, please.
Yeah, I respectfully urge the committee to support HB 5004, Section 6, 7, 8, 9, 14, 20, 22, and 23, and continue advancing reforms that promote child safety, family stability, constitutional compliance, and adherence to recognized human rights standards. Thank you.
Thank you.
If you have any questions, I will be open to receiving.
Thank you so much for your time. Let me just double check. And I am not seeing any questions or comments. We appreciate your testimony tonight. Thank you.
Okay, thank you. Have a good night.
You too. Thank you. Number 21, Ashley Hutchins.
Hi.
Go right
hello.
ahead.
Thank you. Hello, members of the committee. Thank you for having me. My name is Ashley Hutchins, and I'm a parent and a social media professional supporting Bill 344. So many conversations around social platform regulations and age restrictions, yet our children's images and details are constantly being exploited by the places they should be considered the safest. Schools, extracurriculars, sports teams, birthday parties are taking advantage of something that needs to change, and that is passive consent. Many parents do not even know they are automatically opted into their child being used for marketing, and others are signing on to something they do not agree with simply because they do not feel they have a choice. Affirmative consent protects our children. Here's a concerning example. The directory media output was buried in our school portal, and that's as someone who knows what they are looking for. When I found the permissions, I learned I was automatically opted into sharing my child's likeness everywhere, the superintendent's Instagram page, to newsletters, to Facebook. I also learned I was the only parent in my school who had unchecked that box. And that was not because I was the only one who didn't want my child on social media. They had no idea what they were unknowingly authorizing. This is why affirmative consent should be the standard. It's about giving parents the transparent option, not making decisions for them. I started seeing concerning waivers in every aspect of my children's lives. Here's another example. Language from an electronic waiver for my child to attend a birthday party. The photo policy was buried in a long waiver with no way to opt out. By entering the premises, I hereby grant the irrevocable right and permission to photograph and/or record us for all purposes, including without limitation, advertising and promotional purposes and other commercial purposes in any manner, in perpetuity throughout the world, without restriction as to alteration. I waive any right to inspect or approve the use of the photograph and acknowledge that the rights granted by this release are without compensation of any kind. Just let that sit for a minute. You sign a long waiver to attend a birthday party and you grant the right for the business to record your child in any manner without restriction as to alteration to be used anywhere, with no clarification of who at the establishment gets to film my children, even if they are in bathing suits or leotards. It's truly frightening. Parents cannot hide their children away, never enroll in sports, attend a birthday party, or go to a music class just so their children are not exploited. That's not reality. We need to recognize the potential dangers of these permissions that often provide detailed information about the locations of children and their habits. I support Bill 344 because it is about parent choice. Businesses can still use images for marketing, but only if parents have actively consented to it. No more sneaky consent, no more having parents swallow a reality that can have safety consequences. Full transparency, affirmative consent, and a win for our children. Thank you.
Thank you so much for your really thoughtful testimony. It is, having also been the one parent in a school who didn't want that to happen, it's tricky. So I appreciate you sharing all of that. Senator Marr.
Thank you. And thank you for your testimony, Ashley. Where else have you run into this besides the school and the birthday parties?
It's sort of where have I not run into it? I mean, across the board, our nonprofit soccer town organization, our school portal, private businesses for a gymnastics birthday, Sky Zone Trampoline Park, every single business has this photo policy lumped in with all their other waivers. And the problem with it is they pick the most general policies too, that literally give full rights to exploiting children in terms of alterations, in terms of how long it can be used without compensation. And I really commend the businesses that do take the step to allow parents to opt in. There are certain organizations, and like Tumble Jungle is one of them, that says this is our photo policy, click here if you opt into it. And that's the way it should be. There should not be a locked waiver where it's simply your child is ostracized because they cannot attend these things or they're exploited in our marketing in perpetuity. It's just a problem.
Have you had conversations with your other parent friends and talked to them about it? And can you tell me a little bit more about that?
I have been speaking on this for years. There is not one person in my parent circle support this. Like, parents want the choice on if their children are being used for marketing. I have spoken to parents who have been denied entry to things. I have spoken to someone in a different state that says she has never signed her child up for sports because she does not like that she doesn't have a choice in the matter. Like, that comes with its own concerns if we are hiding our children away, but because we don't want to use them for free marketing. Like, these are minors. We don't know where the future of these images can even go with AI in this world. Like, it should be up to a parent if a business is going to be able to take those in a very dangerous way for the rest of their lives. And just even the fact that they can alter them too is just concerning.
Thank you so much. I really appreciate you taking the time to provide the testimony, to bring the subject forward, and to show up to testify. It means a lot. Thank you.
Yes, thank you. I think just one more comment is I've heard say that privacy is going to be the currency of the future. And, protecting our children's privacy from the get-go is a responsibility that we have as parents. So thank you for your testimony today.
I just to comment on that, if I'm able to, it's because when you say that, like the future, I don't think 10 years ago we realized what could happen with these pictures and what the future would look like. And it really is about protecting something that we may not even know what that looks like yet. So I think we just have to do right by the kids. So thank you for listening.
Thank you. Thank you for your time tonight. Seeing no other questions, I think you are all set. Okay, up number 22 is Marissa Bohuniaak. Again, hopefully I'm pronouncing your last name correctly, followed by 23, Julian Stakeley, and number 24 for the United Way, Barbara Channels. Marissa, go ahead. Oh, we can't hear you.
Oh, can you hear me?
Yes, we can.
Okay, beautiful. Okay. Hi. It's nice to see everybody. It was great being at the Capitol building today. My name is Marissa Bohuniaak. I'm a homeschool mother of 3. I was homeschooled in Connecticut, K through 12th grade. I have 6 siblings who are also hybrid homeschooled, private schooled, and publicly schooled for various reasons. So this bill is SB 6 is close to me. Specifically Section 5, because withdrawing students from school was something that my mom did on and off, depending on which child had different needs. Section 5 is entirely inappropriate for SB 6 because of the nature of the other sections in the bill. I completely understand the other testimonies when they say they need free school lunches and all of these supports. DCF has an incredibly difficult job. I have people I know that are foster parents, and I have friends who have been in the foster care system. The idea, I agree with everything that has been said by Senator Daphne, by everybody who has said that they oppose this bill. I agree with all of their sentiments. What really concerns me is the witch hunt-like effect that was stated before, of this idea that we're all guilty until proven innocent. But what's really concerning with me and the parents in my community is that there will be some sort of data collection. And although that language is not specifically put in the bill, and that has been stated that it needs to be clarified, it's concerning how vague the language is in Section 5. It's concerning because it feels like it was written to be kind of a blank space for future legislation, and that is uncomfortable, especially because it doesn't really seem to fit in with the nature of the rest of the bill. So I think that Section 5 needs to be removed entirely, because I think it's also unfair to the other sections of the bill that could be legitimately need to be passed. So Section 5 needs to be removed. And the other concern that I want to put is that, especially last year when we all came to the Capitol, because there was a lot of talk surrounding the Waterbury case that was clearly a DCF failure, and it was being pinned as homeschooled, which we all know is unfair. That's concerning because within the language of that meeting, I went back through my notes, there was a lot of talk on needing to do regular health checks, especially how there's no regular checkups for those in the homeschool community. We have the lowest regulation, but I have family that is homeschooling in the highest regulation state. And it seems to me like that would be a great way to create a registry. So though the language is not in Section 5, it seems really disingenuous to just leave this open space, especially considering how much health was talked about last year, especially because in my specific homeschool community, there is a lot of vaccine injured kids. They are very concerned that this is going to be used as some sort of registry, that they will have to show health identify if they have to do anything, if they have to have vaccines or something. So although that language, again, is not in there, it's all conjecture on my end, trying to put puzzle pieces together. That is a big concern in my homeschool community. I'm open for any questions.
Thank you, Marissa. We have a question from Representative Daphne.
Great.
Sorry about that. Thank you. Thank you, Madam Chair, and thank you, Marissa, for being here today. I guess, there's a lot of people right now who are not very trusting of our government for a lot of different reasons. Do you think if language would be added to that your name would be removed to the from a list that you were once put on, you would feel like that would really be done, or would you feel like it would be floating out in the cloud somewhere?
Yeah, I don't think that adding language to the bill specifically saying that your name would be expunged from any record should no negligence be found. I don't find that reassuring. And I don't think any of the parents in my community would find that reassuring, because all that's doing is pushing the benchmark forward and creating a framework that would feel like it's giving some slight permissions where, well, if there's a crisis, maybe we need those names. Maybe we can pull them. Maybe this is a different circumstance, because we have been fed that narrative before that this circumstance it's necessary to give up certain freedoms that we thought were given. So we're not comfortable with added language to that bill, which is why I think that I speak for most of the people in my community where we say that that whole Section 5 just needs to be removed.
Yeah, thank you for that, because that's what I'm hearing. And I think that, overall too, people feel like, well, why is my name being notified to somebody for something I didn't do wrong? I stopped at the stop sign. I was driving the speed limit. Why are you notifying somebody of something that I'm doing that's perfectly legal? It's good to hear your perspective, and thank you for coming to testify today. Is there anything else you wanted to add to that?
I would like to add one more thing. My mother is a 25-year homeschool mom. She put all of us through high school in some way, shape, or form. She is currently a para in the elementary school in my town. And what she sees is pretty horrifying, and the disrespect and the abuse that she deals with on a daily basis from the students, not the staff, but from the students, is pretty shocking. So there is nothing about being in a public school that makes it a special safe place. And if anything, the safety net that they provide for the students creates a very strange dynamic. For example, if a student has an outburst, the entire classroom has to be cleared. And then that student that has an outburst is put in a special room, a cozy corner. That's what they call it in this specific room. And then there has to be a report filed. This is an insane precedent to me. I know personally, another homeschool mom of mine whose son was assaulted. I won't share personal details because I don't have permission to, but this is not the idea that there's this, that if we withdraw for any reason that we should be suspicious of. There are so many abuses that are going on in the school system, just infrastructure wise. I'm not blaming teachers. It's not even specific. It's just the nature of the situation. We're having a parenting crisis. We're having financial crisis. People aren't feeling supported, which I feel like parts of this bill do address. But again, that's why Section 5 needs to be removed, because you can't move a bill like this forward with Section 5 in it.
Thank you so much for your testimony today. I appreciate it. Thank
You're
you, Madam
welcome.
Chair.
Thank you. Have a great day.
Thank you, Marissa. See no other questions. We will, move on to speaker number 23, Julian Stakeley, and I will pass the chair on chairpersonship onto Representative Kit, who will take the next hour. Thank you so much.
Thank you, Representative.
Hello, how are you? Can you hear me?
Hello, Julian. Yes, it is your time. Why don't you get started?
All
Thank
right.
you.
Hi, everyone. I'm here to support House Bill 5004, Act Concerning Child Welfare Accountability Act. My name is Julian Stakeley. I'm a Colchester resident with a master's degree in social work, prior DCF worker with 5 years experience who left in good standing. I'm also a father to a 5-year-old little boy who's still in the care and custody of DCF. I'm his voice today. I have not had physical contact with my son in almost 7 weeks. This is a system failure. And when we look at how the systems may have failed, I believe that we must look to the guardian ad litem and the attorneys of the children who are there to protect the child to ensure those visits are happening. They are their voice also. They have a duty and to an act to ensure when things break down, they don't get lost. All right, I lost my thinking. 5-year-old children and younger are the most vulnerable populations. They generally can't speak for themselves. And at times I know there's an attorney at litem, and perhaps maybe when the children are younger, we have a guardian ad litem too, to ensure their voices are heard. I think there also needs to be some type of either sanctions or something in there to we ensure that the children are being protected by the attorneys assigned to them. It's their job, and I'm hoping that through the Accountability Act that we can highlight the system failures and ensure that our children and everybody's children out there are being protected by the attorneys that they are assigned. And that's my testimony. Thank you guys for hearing me out today.
Thank you so much, Julian. I'm sorry to hear that with the trials you're going through. I really appreciate you sharing your stories. If you just want to make sure that nobody has any questions for you, seeing none, I want to thank you and best of luck.
Thank you. Bye.
All right, next up we have Barbara Channels from United Way of Connecticut, followed by Merrill Gay, followed by Quinn Mihan, followed by Thomas Bonanno. So Barbara, if you're there.
Yep. Can you hear me?
Yes, I can.
Okay, great. Well, I said good afternoon, and now it's already good evening. So good evening. My name is Barbara Channels, and I'm from Torrington. I'm reading off my notes here. I'm here today to tell you all my story. I support the free lunch program and the child tax credit. I'm a retired 30-year letter carrier for the United States Post Office and a Army veteran, a wife, a mother, and a grandmother, now mother, to Jack. I'm here today to tell you a little bit about my story, our story, and Jack. Our grandson, now son, came to us at birth, and we have raised him, adopted him, and loved him since 2014. In the years of the challenges of raising a child has been difficult from when my first 4 children, first generation children, grew up. In today's young generation, there is so much technology. If a person over 60 needs to program their cell phone, give it to a 10-year-old and it'll be done in minutes. Technology is expensive. Internet, Wi-Fi costs, tablets, downloads. In today's generation, kids need to feel like the crowd, with their shoes, clothing, games, sports, and activities. Children today not only want, but need. To raise a son or daughter now, factor in food, clothing, education, be it religious-based or public school, which all bring extras. When Jack was first born, I was grateful for the WIC program that I qualified for, being a foster parent. When the store clerk would place the case of formula on the register and it totaled over $100, I was so grateful for the WIC program. I don't think we could afford to do it back then in 2014, along with childcare costs, diapers, and other expenses. When Jack entered kindergarten in first grade, the pandemic hit. Everything shut down. School was online. Being home 24/7 with Jack was a challenge. Providing well-rounded, tasty meals was a challenge. When the school session resumed, we were able to receive free lunches. Everyone, regardless of income. This now included breakfast and lunch, and I would provide a midday snack. This is a great help, as I remember in the past for my 27-year-old, I would write a check when he was in grade school every month for the school lunch program. When the account was low, parents would receive a letter letting them know that the balance was near zero. If the account went to zero, the child would receive a peanut butter or cheese sandwich.
I'm sorry, your time is just about up. Could you summarize, please?
Sure. The paid school lunch program allows children to focus on their studies, physical activities, and independent growth to become a better student and athlete. I highly support the continuation or startup of this program for now and in the coming years for the youth of Connecticut. Thank you.
Thank you so much. And as an adoptive mother myself, thank you for taking on the care of Jack, and I hope he's doing well and thriving.
He is. Thank you.
Well, thank you so much. I'm just going to check to see if there are any questions for you. Seeing none, you are free to go and have a great night.
Thank you. Have a good evening. Yeah, bye-bye.
All right. Next up, we have Merrill Gay of Connecticut Early Childhood Alliance. Merrill, are you with us?
Yeah. Senator Mayor.
Hi, Merrill.
How are you? Representative Paris, ranking members Perillo and Dauphinais, and members of the Children's Committee. My name is Merrill Gay, and I'm the Executive Director of the Connecticut Early Childhood Alliance. The Alliance brings together over 80 organizations dedicated to improving outcomes for young children through policy change. Thank you for this opportunity to testify in support of Senate Bill 6. Specifically, the Early Childhood Alliance supports Section 1, which creates a fully refundable child tax credit of $600 up to a maximum of $1,800 per family, and Section 2, which provides free school meals to all students. Connecticut's families are being squeezed. Their two largest costs, housing and childcare, are rising substantially faster than the official inflation rate. For families who are welcoming a new baby, tariffs have added approximately 25% to the cost of car seats, strollers, and a bunch of other baby necessities. It's getting more expensive to raise children in Connecticut. We see this in the official, we see this reflected in the United Way's ALICE data, with a growing number of families, now 40%, falling below the ALICE survival budget. So it's time that Connecticut join our neighbors in the region and provide a child tax credit. New Jersey, New York, Massachusetts, and Vermont all provide tax credits of $1,000 for young children, a little less for older children. Maine is now at $600 for children under age 6, $300 for families for children over 6. And even Rhode Island has just proposed a child tax credit. So it's time we join our neighbors. And the way this bill is written, the bill would phase out the tax credit when families reach $200,000 for a married couple. So that means that roughly 75% of the children in Connecticut would benefit from this credit. Section 2 would make school meals free and ensuring that children aren't hungry at school and saving families roughly $1,000 per child in food costs. We know that it's hard to concentrate when you're hungry. And as the federal government imposes new restrictions and administrative barriers that will cut families off of SNAP, the number of school districts qualifying for free meals under the community eligibility provision is likely to fall. Making school meals free is something that state government can do to ensure that no child goes hungry. I hope we can do this, and I thank you for this opportunity to testify. I'd be happy to answer any questions.
Thank you so much. You know, I agree, hungry kids can't learn, so I think this is a very important policy that we're trying to adopt here. Seeing no other questions, thank you for your time and have a great night.
Okay, thank you.
Okay, next up we have Quinn Mihan, followed by Thomas Bonanno, Kate Anderson, and Ralph Rodriguez. Quinn, if you're here, we would love to hear from you.
Yes. All right. Co-chairs, ranking members, and members of the Committee on Children, thank you for the opportunity to submit testimony in support of Senate Bill 6, an act concerning supports for children and families. I'm Quinn Mihan, community organizing and policy MSW intern at Universal Healthcare Foundation of Connecticut, a former special education teacher in New York City, Bridgeport, and Waterbury public and charter schools, and have history as a child of being involved in DCF cases. Universal envisions a world in which justice prevails, health is respected as a human right, and equity is realized. We support Senate Bill 6, especially sections 1, 2, and 5. Connecticut's children deserve to be safe, healthy, and have access to an appropriate and equitable education. Sections 1 and 2 have been spoken about. They are crucial to supporting the economic success of our families, the well-being of our children. This is especially important considering the impact of the COVID-19 pandemic on children's needs and families' financial states. Families need this money in order to be able to afford additional supports like therapy and academic tutoring that are not already covered. Additionally, free school lunches are crucial for, as has already been mentioned, academic success, and they not only benefit or are important for families who can't afford food, but also for families who simply don't have the energy to make a meal, who have forgotten and have left their child hungry for the day unintentionally, or who are struggling to pay for food that meets their child's food allergies or dietary restrictions. I know growing up, my mom, who's disabled, was able to give me a few dollars when she was in too much pain to make me food, but not every child has that option. Finally, we support Section 5, which creates a basic notice requirement when a child is withdrawn to be homeschooled. States such as Massachusetts and Rhode Island require annual assessments and require parents to seek approval from their local school district before homeschooling. In New York, parents must file annual notice with the local superintendent, submit an individualized home instruction plan, and provide quarterly progress reports. Connecticut is only one of 11 states that does not require any notice of homeschooling or any of the restrictions I just mentioned, and only one of 2 in the entire east side of the country. This bill does not ban homeschooling, and we are not of the belief that parents are inherently doing so with malintent. In fact, I've heard many stories recently of parents in my research who have had wonderful success pulling their children out to homeschool because of harassment for being trans. However, child welfare laws were written before homeschooling was widespread and rely heavily on mandated reporters within school. When a child disappears from the school system without notice, there may be no consistent point of contact to ensure their safety or educational progress. Children with disabilities and children already involved with DCF are particularly vulnerable when withdrawn without notice. I know several families have mentioned that they have many points of contact with mandated reporters or other people in their lives, but not all children have this.
I'm sorry, Quinn, your time's about up. Could you summarize, please?
Absolutely, thank you. Universal urges the Committee on Children and the General Assembly to pass SB 6 to strengthen economic stability, reduce food insecurity, and ensure that all children in Connecticut, regardless of where they are educated, remain visible, protected, and supported. And I just hope that the Committee on Children recognizes that some of the children that are most vulnerable cannot be here to testify today, while parents who are in support of this bill can. And so it's important that we are listening and considering the needs of those children.
Thank you so much, Quinn. Now, we've heard a lot of opposition to Section 5. Would you mind finishing your testimony on why Universal Health Care Foundation supports that section?
Yes, thank you. In 2018, the Office of the Child Advocate, as they mentioned earlier today, did a study following the death of a student with autism and intellectual disability who suffered abuse at the hand of his family after being pulled out amidst a DCF case. They also found that among 380 students withdrawn from 6 Connecticut school districts for homeschooling, 138 lived in families with at least one prior accepted report of suspected abuse or neglect. These findings underscore the importance of ensuring that children withdrawn from school are not rendered invisible to the systems intended to protect them. That is the majority of what I wrote in terms of verbal testimony. However, I've included more detail in my written testimony, and I'm happy to answer any questions.
Thank you so much. I believe Representative Daphne, you have a question?
Thank you. Representative Kidd. I appreciate it. And thank you, Quinn, for being here today. My question is, you said that you support Section 5 in SB 6. Is that correct? I just want to clarify first.
Yes.
Yeah. So tell me how that would help a child. So the way it's set up now in the bill is that all children who withdraw, all of them, will be reported to SDE, and the SDE will report to or notify DCF, and DCF will merely check a list and put a note in the chart of those who are already, I thought, substantiated cases, but it sounds like open cases. So if if they are put in the chart, it just kind of flags them as they pulled them out of school, and all the other ones are disregarded. So tell me where you see that helping, because the tragic cases that I've heard wouldn't be changed at all by this. So can you explain?
Sure. I mean, I'm not an expert in this at all, so I'll just frame it saying that. However, as a teacher, we have an eye on kids, and we have a note of, which kids are in our care, whereas we don't have those names of those other children that are pulled out. And so I think even having an awareness of who those children are and where they are is important, especially if there is an open case of any kind, and just allowing DCF, hopefully with maybe some of those additional improvements made by House Bill 5004, was it? Or 5002, one of the two, can follow up on that. And I do think that there is some gaps in the child welfare system in addressing that. However, right now we have nothing. And it's important to consider that most states, especially in the East Coast, do at least have at least keeping track of students. And if not, they're mandating assessments and really ensuring that not only are parents keeping their children safe, but are receiving are receiving an adequate education. And so if anything, I would push for some of those things, but here we are, we're testifying on the specific bill. So yeah, I don't know if that answers your question, but those are my thoughts.
Well, it doesn't really, because nothing in SB 6 Section 5 does any of what you just mentioned. So I was just curious, and I think you kind of proved my point that none of what they're doing in SB 6 Section 5 will do any of what you suggested. They won't have mandated reporters on them. They're saying they won't keep a list of the names. So I'm not seeing it. And I was hoping that you might clarify for me, but I thank you today for your testimony. Thank you, Quinn.
Okay.
Thank you, Representative Dauphinais. Quinn, we have a question from Senator Maher.
Mm-hmm.
Hi, Quinn. Thanks so much for being here and for providing testimony. I think what I heard you say, and please correct me if I'm wrong, is that when someone is taken out from schools and they have a case with DCF, that there is no longer a mandated reporter with oversight or eyes on that child. Is that what I was hearing you say?
I mean, in most cases, I would say so. Obviously, some parents might have their children in specific programs where there's a mandated reporter, but the majority of DCF calls and reports come from schools. And that is where the majority of mandated reporters exist, from teachers to social workers to speech language pathologists. It is, if a parent is choosing to keep their child at home, it is very easy for them to not experience a mandated reporter.
Okay, well, I just wanted some clarification on that. I appreciate you being here. I appreciate you giving testimony, and thank you so much for your time.
Representative Dauphinais, is your hand up from your last question, or do you have another
Yes,
question?
please. I just wanted to follow up. Quinn, so if according to this bill in Section 5 and in SB 6, there's no mandated reporter's eyes on anybody unless they're already being followed by DCF or in an open case with DCF. So I'm still not getting clarification as to why you think a mandated reporter would be then following them once they left the system. So I just wanted to make that statement. I'm trying to clarify here because it's very confusing. And I wanted to make sure you understood that is not what SB 6 Section 5 is doing as stated here today. Thank you.
May I just comment quickly?
Yeah, sure.
Obviously I did not write the language in the bill, but I would say that our current situation also doesn't have mandated reporters currently looking at those students. And so I would say that it is important. I will just say broadly that we should have some system of having any sort of eye on those children. Even if it's not in the bill, then I would encourage this committee to look at those sorts of protections.
Okay, thank you. I appreciate that because that is what they're saying is not in the bill and not their intention. So thank you so much. I appreciate that.
All right, thank you, Quinn. I'm not seeing any more questions. So thank you so much and have a great evening, and thank you for sharing your testimony. Next up, we have Thomas Bonanno. I hope I'm pronouncing that right. Followed by Kate Anderson, followed by Ralph Rodriguez, followed by Sharon Toppin. So Thomas, if you're with us, we'd love to hear from you. Thomas, I don't see you here. So moving on to Kate Anderson.
Good evening. My name is Kate Anderson, and I'm the mom that Representative Foster mentioned earlier in her testimony. And I'm here testifying in advocacy for stronger DCF investigations in schools because the current system failed my family when we needed it most. This past October, my son, who has spastic quadriplegic cerebral palsy and is nonverbal and non-mobile, came home from school with extensive wounds that he did not have when I put him on the bus that morning. I do have photographs I'm happy to share, but please note that they might be upsetting to some. We immediately contacted the school, filed a report with DCF, and contacted our local police department. We trusted the system to protect our child and provide answers. What we got instead was a broken process. First, there's an inherent conflict of interest when the institution responsible for a child's safety investigates what happened on their watch. School principals and educators are not trained investigators. They have every incentive to protect their staff and minimize liability. Making matters worse, taking legal action against schools is extremely difficult due to sovereign immunity. This means families have limited recourse even when their child is harmed. When schools can investigate themselves and are largely protected from legal accountability, where does that leave our most vulnerable students? Schools also need more cameras in areas where vulnerable students congregate. If there had been more cameras, or if cameras had been placed correctly, we might have had more answers. Instead, we only have questions. Second, the investigation process lacks transparency and communication. We were given a brief summary that raised more questions than answers. What we didn't know, and no one told us, was that we could request a full detailed report, which would take 90 days to receive once requested. Third, we were never informed of what, if any, legal options we might be available. No one explained what recourse we had, what rights we possessed, or what steps we could take to seek justice for our son. We were left to navigate an impossible system alone, where our child's injuries went unexplained and unaddressed. I do want to acknowledge the people who went above and beyond in this process. The police detective from our town was amazing, and I truly believe we wouldn't have gotten the Klingberg Center for Forensic Interviewing without his dedication and advocacy. At Klingberg, my son participated in a forensic interview with an incredible and understanding interviewer. She did extensive research to fully understand my son's communication process and worked with him in a way that respected his intelligence and capabilities. Her expertise showed what's possible when professionals are properly trained. But this highlights another critical gap. More training across all agencies, schools, and even hospitals is desperately needed in how to properly interact with nonverbal children. These children are significantly smarter than they are given credit for, and they have ways of communicating if you just know how to listen. My son cannot tell us what happened to him in the traditional sense. He cannot advocate for himself in ways that the system would recognize. So the outcome, no justice, no answers, and no accountability. I'm asking you to strengthen DCF investigations in schools by 1, prohibiting schools from self-investigating incidents involving students, require independent trained investigators, and address sovereign immunity protections that shield schools from accountability. 2, require video monitoring classrooms and spaces, serving vulnerable students to protect both students and staff. Mandating transparency, automatically inform families in writing of their right to request complete reports, the timeline, and any legal options that might be available. 4, mandating interagency coordination. DCF, law enforcement, and schools must learn to work together better, share information immediately, and each be held accountable for their role in protecting children. And lastly, mandating training for all agencies and school personnel on how to properly communicate with nonverbal children. When a child cannot advocate for themselves, the standard of investigation must be higher and not lower. No family should have to fight this hard for answers when their child is hurt, and no child should be left without justice because the system is designed to protect institutions instead of students. Thank you for your time and consideration, and I'm happy to answer questions and show any photos for anyone interested.
Thank you so much, Kate. And I'm so sorry for what happened to your son. And I don't want to speak for everybody on the committee, but I'm pretty sure we're all here because we are committed and devoted to protecting the health and safety of our children. And hopefully your testimony will help us to create policies so that it doesn't happen to another child. It looks like we have a question from Representative Dauphiné.
Thank you, Representative Kit, and thank you for your testimony today. My heart breaks for you and what you went through. I have a special needs daughter who's an adult now, and I can 100% relate to every single experience that you've had. Not that I had that specific experience, but they don't verbalize like other kids, and we have to really advocate strong for them. And I appreciate your testimony in particular because that's where I think we should be putting our focus on right now is the failures of what's going on in the public school where there's mandated reporters looking at kids every single day. And now we're going after a group of people in another bill that have done nothing wrong. So I'm completely with you and understand what you're talking about and agree with you. And I think that the system has failed you and we need to correct that. So thank you so much for your testimony today.
Thank you.
Thank you, Kate. And seeing no other questions, you're free to go. Enjoy your evening.
I just wanted to respond. There was a question earlier from Senator Mayer, if I'm pronouncing your name correctly. To answer your question, no, we still have not received the full report of what happened to my son. So we're still kind of just, we know something happened, but we don't know what the investigation showed because we haven't gotten the full report.
Thank you for that. Again, I'm sorry for what your son went through, and hopefully we can prevent that from happening again.
Thank you.
Next up, we have Ralph Rodriguez, followed by Sharon Toppin, followed by Kora Stove, then Katie Dormont. So, Ralph, if you are here, we would love to hear from you.
Thank you, Madam Chair. Good evening, members of the committee. My name is Ralph Rodriguez, and I am an attorney with the Homeschool Legal Defense Association. I just also want to note we're on Zoom, so I've tried to conspicuously put my lobbyist badge on my lapel. I just thank you also for the opportunity to testify concerning Senate Bill 6. HSLDA supports meaningful reforms that strengthen protections for children from abuse and neglect. And we believe that sections 3 and 4 of SB 6 represent constructive steps toward improving accountability and responsiveness within the child welfare system. And so we commend the committee for addressing those important issues. However, we respectfully urge you to amend SB 6 by removing Section 5. Connecticut has long been a state that recognizes and respects educational freedom. The law has trusted parents to direct the upbringing and education of their children, consistent with long-established constitutional principles. However, Section 5 marks a significant departure from that tradition. It would move Connecticut from a posture of parental trust to one of institutional suspicion. It would formalize a system in which all families who withdraw their children from public school, including those who homeschool, are automatically routed through state-level reporting mechanisms. Even if they disclose that they plan to exercise their legal right to educate their children privately and actually do so. Section 5 increases regulation in a state that has historically avoided unnecessary oversight of homeschool families. More importantly, it treats parents who make lawful educational decisions as presumptively suspect. Child protection law should be targeted and narrowly tailored to address demonstrated risks. Broad measures that sweep in every withdrawing family do not distinguish between families in crisis and families exercising constitutional rights responsibly. Parents possess the fundamental right to direct the upbringing and education of their children, and legislative measures that burden that right must be carefully calibrated and narrowly tailored. When the state treats a lawful withdrawal from public school as an event warranting automatic reporting across agencies, it moves away from that careful balance and infringes upon liberty. Connecticut can strengthen its child protection framework without transforming its homeschool landscape or casting suspicion on families who are acting lawfully and responsibly. For the foregoing reasons, we respectfully urge this committee to amend SB 6 by removing Section 5.
Thank you so much. I see that Representative Dauphinais has a question. Representative Dauphinais, the floor is yours.
Thank you, Ralph. Thank you. It's nice to meet you. Thank you. Welcome for helping the homeschool community who I'm very familiar with. And I've heard from many, many of them. And I just maybe touch on a few things and maybe you could speak to it. They're feeling like they're put up for trial and they haven't done anything wrong. I gave the example earlier of literally they stopped at the stop sign. They weren't speeding. They did everything right. And now they're going to have to be notified to DCF, which is an agency that checks on children that have been abused, neglected, and the like. And I'm, maybe you can speak more to the constitutionality of that. I mean, I did ask earlier, there is no precedence for this. There's no precedence for any person to be reported or notified to DCF for something that they did lawfully and legally. Maybe you could speak to that.
Yes, that's absolutely correct, Representative. And it would be unprecedented in this country. Once again, it not only transforms Connecticut from a no notification state, virtually no regulation state, but it goes a few steps further than even the high regulation states like Pennsylvania, like New York, where I'm from, in which it's also already been mentioned that there are high level of paperwork and reporting mechanisms for parents who homeschool their children in those states. But this bill, the language, if this would be passed into statute, would treat parents as presumptively suspect of committing crimes. It's a bedrock foundational principle of our U.S. jurisprudence that you are innocent, you're presumed innocent until proven guilty, and that the language in this bill flips it on its head. And so it's very concerning. It would make Connecticut by far the worst state, not just to homeschool, but to privately educate one's child.
Thank you for that. And I find it really interesting that the claim is that they won't keep the data. So you notify, you have this list, you notify SDE notifies DCF. The only thing they're doing from what the claim is in Section 5 is they're going to put a note in the file of children that are already being investigated. So it almost seems like a nothing bill, right? DCF came in and claimed that they already pay attention and are following children that are being investigated and know where they're going to school, who they live with, and so on. So if it's a nothing bill, then why are you having this list of names? And I think you heard maybe in earlier testimony, people are concerned where this list is going to go. And maybe you can speak to that, because I think that's a huge concern for many people. And then furthermore, we heard from a mother whose child was abused in our school with mandated reporters. And now we're going to expand DCF, give them more, if you will, jobs to do, right? More work to do, and they can't even manage what they're supposed to do. It seems absurd. I don't know. Maybe I don't know about other states. So maybe you can speak to that and the outrageousness of this bill or this section in this bill.
Yeah, I would like to respond to the first part of your comments there. Part of the reason for part of the reason why the language in the bill is problematic, it's because it's overbroad and also vague, right? So it's sweeps everybody under one category and it treats them the same. But we also don't believe that expunging the list or expunging names that are reported to DCF because there's no substantiated claims, we don't believe that solves the problem either, because that first step is taken in the first place. And once again, it treats the parents who are making a lawful decision, as you've pointed out several times in this session, as presumptively suspect. And so, that's the first and foremost problem with what's going on in this language. I agree that there can be changes to DCF, and I think everybody that's listening to this committee believes that changes can be made. I think that's the case across the country, but we don't sweep law-abiding citizens into that same conversation when you're trying to come up with reform. What I can also say about other states is that no matter whether you come from a high regulation state when it comes to education or homeschooling, or a low regulation state, there are always going to be instances of reporting to child welfare systems. So whether there's increased paperwork or not, that doesn't solve the causal link of trying to solve child abuse or neglect. And so, we work across the nation at HSLDA, and we have membership. I believe it's all over 90,000 members across the nation. And so we have members from high regulation states, low regulation states, and we don't believe that what's proposed in Section 5 is going to solve the stated problem.
Thank you so much. Thank you for being here. I mean, I've talked to literally hundreds of homeschoolers in this state, and they're horrified by some of the things that have recently happened with some of the children, none of which fit this if you will, policy change that would have changed the outcome for any of them. And unfortunately, I don't know that we're going to be able to get rid of all the evil. And these people were evil. They were evil to those children, and it was horrific what happened. But thank you so much for being here today, and welcome to the community.
Thank you, Representative.
Thank you, Ralph. Seeing no more questions, you're done for the night. Thank you for being here with us. Next up is Sharon Toppin, and followed by Kora Stove and Kate Dormont. So Sharon, if you're here, we'd love to hear from you. Sharon? I see you're still online, but I can't hear or see you.
Can you hear me now?
I can hear you now, yes. I can see your avatar. You look like a lot of fun.
Okay. Thank you. I just want to read my testimony.
Sure.
If that's okay.
Absolutely.
Hold on. It says, Dear Senate Mercher, I'm not sure how to pronounce her name. Representative Paris and members of the Committee on Children. My name is Sharon Toppin, and I am a mother, and I am on disability. Thank you for the opportunity to submit testimonies in my support of Senate Bill 6, an act concerning support for children and families. I support this bill because it would create a child tax credit and establish non-cost school meals, both breakfast and lunch, for all public school children. I am a caregiver for my children, especially for my son who is intellectually disabled. He also has anger issues, which he needs help with. Because most of the time he can't speak, speak for himself. A $600 child tax credit would help a lot with my bills, as well as affording food, rent, and clothing. If Connecticut helped its citizens more, everyone could survive. If they invested in our communities, things such as public schools, healthcare access, and food justice wouldn't need to be cut for lower class neighbors. We are here to hold you accountable for your actions. Please lower prices and make sure that working class people can begin to win in CT too. I strongly urge the committee to vote in favor of this bill. It is time for Connecticut to invest in women, children, families, and workers. Thank you for considering my testimony.
Thank you so much, Sharon. Your audio cut out in the last sentence. Would you mind repeating that for the committee?
Oh, it says, I strongly urge the committee to vote.
Oh, you cut out again.
Sorry, my daughter keeps calling in, so that's
Oh,
why. I'm so sorry. I
that's
strongly
okay. I get that all the time too.
yeah, vote in favors of this bill. It is time for Connecticut to invest in women, children, families, and workers. Thank you for considering my testimony.
Thank you so much, Sharon. I want to maybe correct you just a little bit. You mentioned that this tax credit would help, or that we should be helping people survive in here in Connecticut. I would say that we should be helping people thrive in Connecticut. It's not just important to survive, but I think everybody living here needs a little help to make sure they can actually thrive and grow. So I want to thank you for sharing your story and your testimony. Um, Seeing no questions, you are done for the night, and you better call your daughter back or she'll be worried about you.
Yes, I'm about to. Thank you. Have a good
Thank
night,
you.
ladies and gentlemen.
Thank you so much.
You're so welcome.
Next up is Kora Stover, followed by Kate Dormont, followed by Jacqueline Torres, followed by Ivy Royster, if they're still here. So, Cora, if you would like to start, go ahead.
Thank you. Thank you very much for allowing me to provide my testimony. Greetings to all of you who are bringing these bills forward and putting in a good faith effort to make Connecticut better. I support a lot of what was going through, except for Section 5 in SB 6. As a physician and professor, I am a mandated person who has to give reports on people who are getting abused or suspected abuse. In my practice, I see from very young to very old, so it's it happens sometimes, but for the most part, you don't have to do that unless there is a real good, suspicion that there's abuse. The other aspect, hold on, I'm just going to grab this little piece of paper. I do not support and I strongly oppose Section 5 of SB 6 because I don't see why you would want anyone's name to be just given over to DCF without some sort of substantiation. Anytime DCF gets a name, they're supposed to check it. I know that it was stated, oh, they're going to check it against a list for open cases, but they're supposed to, their job is to make sure that there's not abuse happening. They're supposed to investigate. And anytime you hand over a name to DCF, their job is basically to go through that investigation. And investigations can be very intrusive. And if the parent isn't doing anything wrong, it can be quite traumatizing to the whole family. So I strongly oppose that. And I would not feel comfortable having my name or any of my friends' names or patients' names or anyone's names unless there was a reason for DCF to get involved. I think that's a little suspicious, and I wouldn't be okay with that. So I strongly oppose that, and I hope that you can, remove that part completely and then go ahead and pass the other parts. I think that the assistance for the foster care and higher ed and stable homes, I think that's super important. Anybody that goes through trauma, their brain is developing differently, and then it's altered completely for a long period of time. Our brains don't develop till 25 years of age, so extending them and allowing them more time to complete their studies, I think would be good, with some sort of structured foundation, home, security, food. Those are basic necessities that we have to look at. I understand, sorry, I'm bouncing back. I understand why they want to do the SB 6 because of those cases, but I don't see how it would have changed it. And the other part too is that if we're really looking to decrease abuse on our children, then when we have those DCF cases, we really have to analyze and figure out what the needs are of those people instead of creating this, funnel bottleneck where we're going to be reporting people left and right.
Okay, Dr.
And
Stover,
possibly
your
doing
time's
harm.
up. Could you summarize, please?
Sure. So I strongly support all the bills except for Section 5 of SB 6. Thank you very much.
Thank you so much, Dr. Stover. Representative Dauphinais, you have a question?
Thank you, Representative Kit, and thank you, Dr. Stover, for being here today. I think your testimony holds a lot of weight coming from being a mandated reporter and being a medical professional. It means a lot, and I think that that's how the community feels. They feel as though they've done nothing wrong, they've done everything right, and for whatever those personal reasons are, they're making a decision to withdraw their child, and now their name will be notified to DCF. And I think that's really concerning, and I think you nailed it. And I just wanted to thank you for your testimony.
Thank you.
Thank you, Dr. Stover. Seeing no other questions, you are free to go. And
Thank you.
Have a lovely evening.
You as well. Thank you.
Thank you. Next up is Kate Dormont, followed by Jacqueline Torres, followed by Ivy Royster, followed by Joyce the Voice. Kate Dormont, Kate, go ahead.
Members of the Children's Committee, thank you for the opportunity to testify in support of HB 5004. My name is Kate Dormont, and I've been working with foster youth for over 20 years. In that time, I've worked directly with youth in the community, brought them into my home, and left my career to pursue my MSW and JD to focus on improving child welfare systems. While I'm currently a student at UConn and an intern at the Office of the Child Advocate, today I'm here to share thoughts based on my own experiences. All of the opinions I share with you are my own and do not represent UConn or the Office of the Child Advocate in any way. I was a licensed foster parent in Connecticut for a decade. Throughout those 10 years, I had kids as young as 1 and as old as 17 come into my home. I worked with DCF social workers, attorneys, educational advocates, and behavioral health providers. I met with countless DCF workers to advocate for youth in my care. I called 211 and worked with mobile crisis. I spent hours in emergency rooms with youth experiencing suicidal ideation and made daily visits when those youth in my care received inpatient placement. I eventually adopted kids who were never able to go home, and I accepted a transfer of guardianship for a teenager with nowhere else to go. I've interacted with many parts of the child welfare system in Connecticut, and I appreciate your focus and attention on holding DCF accountable. There are many parts of this bill, such as broader inclusion and transparency in kinship care, and increased access to post-secondary education that will positively impact youth. But there are also critical pieces missing from this legislation. Every youth, with the exception of one who came into my home, was coming from a prior foster placement. After the traumatic experience of being removed from family, they were struggling to regulate emotions and make appropriate choices. They did not receive the behavioral health services that they needed, and as a result, they acted out. When adults could not manage their behaviors, they bounced from placement to placement, compounding their feelings of instability and the sense that adults were not able to help. When behaviors became acute enough to require a higher level of care, they waited to receive services. And when they were eventually stable, they were discharged to a wait list for more services with instructions to call mobile crisis or police if behaviors escalated while they waited again. There are real workforce challenges in child welfare and behavioral health systems across the country, but we cannot use that as an excuse for performance that doesn't meet the mark. And a dashboard built on inaccurate data and another committee making recommendations that DCF can pass over is not going to make children's lives better. Legislation needs to focus on providing a full continuum of care without gaps. We must identify clear goals and metrics aligned with DCF's mission to help children thrive instead of defining success by the number of children in care. DCF should provide anonymized, raw data to partners and researchers so that they can hold the department accountable and offer recommendations that solve real issues. And finally, DCF must get input from others. Instead of asking if we're doing better than other states, take what is working elsewhere, like New Jersey's system of care and service array, or wrap around Milwaukee and Wisconsin, and adapt those programs to fit our context. But most importantly, consult people with lived experience, not just foster parents, caregivers, or providers, but youth and parents who've been directly impacted by DCF. Make sure their voices are not only raised, but trusted as experts in their own experiences. But however the legislature chooses to move forward, it is critical that youth and families participate in evaluation, serve on advisory boards and committees, engage in planning and implementation activities, and develop policies and procedures to make sure our child welfare system meets its vision that all children in the state are safe and sound within loving and supportive families. Thank you for your time, and I'm open to any questions that you may have.
Thank you so much. Could you just state again what bill you are supporting here?
5004.
Great, thank you. I want to thank you so much for your work with this very vulnerable population of children and for opening your home and your heart to all of your foster kids. And I wish you all the best of luck in finishing your studies. We need more people like you out there. Seeing no other questions, I want to thank you for your testimony and you did a great job with your testimony and come back anytime. And you're free for the evening. Have a
Thank
good
you.
night.
Good night.
Next up, we have Jacqueline Torres, followed by Ivy Royster, followed by Joyce Castellano, and Pam Lukashu. Sorry. All right, Jacqueline Torres, if you are still here, please join us.
Hello, good evening. I would just like to testify on a personal level, but also give my perspective as a former foster child. My name is Jacqueline Lorty. I'm 26. I am a wife, a mother to 2 boys, a 3-year-old and a 5-month-old today. I'm here to just bridge the gap between the child that I used to be, who relied on school meals for survival while in the foster care system, and the working mother that I am today, who is still fighting to keep her head above water. My family is in a difficult position. We are considered over income for the earned income credit and the programs that once held our lives together. We work hard. I have a full-time job and I work side hustles to make ends meet. Yet every 2 weeks, I'm forced to play a dangerous game of financial Tetris, deciding which bills I can hold on off or like for just a few more days so that my family can eat. I am incredibly grateful that my sons attend a school that provides free meals and free formula. To many, that sounds like a perk, but to me, it is a lifeline. A single can of formula costs between $25 to $50. When you're balancing rent, utilities, car bills, and the basic cost of living, $50 for a few days of milk is sometimes just all I have left. In my professional life, I work with foster youth. I see the circle of poverty continuing every day, but in my personal life, I'm living the reality that even making it out of the system doesn't mean you are safe. It's an everyday fight to survive, and truly, it is exhausting. The $600 tax credit and the universal school meals or providing free or reduced meals for children aren't just the line items on a budget. They are the difference between a mother like me choosing between the electricity bill and a grocery store. They ensure that children, including my own, never have to wonder if their school lunch is their only meal for the day. I am doing everything right. I am working, I am contributing, and I am raising the next generation. And I'm asking you to do your part to ensure that family like mine, who work too much to get help, but not enough to be secure, don't fall through the cracks. We can't keep asking children to learn on empty stomachs and then wonder why the cycle of poverty never breaks. Providing these meals and this credit isn't a hard choice between possibilities. It is a choice between a future for our children or a continuation of their trauma. This isn't a budget cut, it's a lifeline. And the wealthiest nation on earth, a child's meal is a basic human right. Um, so yeah, just wanted to share my perspective.
Thank you so much for sharing your story.
You're
It's very
welcome.
powerful, and I am, glad to see you growing into a mom and who's supporting herself. And
Yeah.
you're right. We need to make things a little bit easier for parents here in the
Yeah.
state.
And it
So
wasn't easy. And hearing you guys talk about the bill for DCF and with the withdrawal of students, I have mixed feelings as a former foster child. I share the same name of Mimi Torres, and growing up in foster care, I also was abused, and I feel like if um if homeschool back in when I was raised was as popular as it is now, and I was withdrawn from the system, I don't know if I would be here today. So in the perspective of a youth in foster care, it is scary to be withdrawn from a system. Um, but I also understand having your name in a database.
thank you for sharing that perspective. It's very important for all of us to hear. Representative Corey Paris, our chair,
Thank you, Madam Chair. Representative Kit, I just wanted to offer a few comments to Ms. Torres. First, I think it's befitting that you share the same name as Mimi Torres, but I say that for a reason. We're living in a day and age now where it is almost impossible for a family to do absolutely everything right and still be able to afford to take care of their kids in the best ways possible, as honest as possible. We're seeing less and less young people wanting to have families and have children, but instead want to turn to being fur parents. We also see that even single adults and also elderly and aging citizens are having trouble making ends meet, and many of them being forced back into the workforce. So I just want to thank you for saying this, because no matter how much we tell people to play by the rules, no matter how many times we say that this is the roadmap to what we describe as the American dream, the goalpost has always moved a little bit more. And so we feel certainly for you and your family. We appreciate all that you do for our state. But maybe, seeing how you've come out of the foster care system, I would also argue that your pathway was much harder because of your upbringing and beginning, but it's not going to be impossible if we do come together on many of these issues. So I just wanted to provide that comment. And we may not have gotten it right, or we may not be able to see the success and what would have become of the other Jacqueline Torres, but we certainly want to be here to support this one. Thank you, ma'am.
Thank you. Thank you so much, Jackie, and for sharing your story. And I hope you'll keep coming back and sharing your story.
For sure.
All right.
Thank you so much for the opportunity.
Seeing no other questions, unless Representative Paris, your hand was up from before. Okay. So seeing no other questions, please go have a great evening, and thank you again for being here. Next up is Ivy Royster, followed by Joyce Catzalano and Pam Lukatsu. Ivy, if you are still with us.
Yes, good evening. Thank you for having us. My name is Ivy Royster. This is my daughter, Charlie Royster.
Hi.
And we are here in support of the child tax credit and also the free meals. Charlie is 11 years old and she goes to school in Stratford and she's in the 6th grade. And she would just like to kind of explain why she feels that free meals are a good idea.
Hi, my name is Charlie.
Speak up.
I think free meals are good because some people don't have a lot of money these days and money is getting tight, and some people just really need some free lunches that would help them out.
And why do you think it will help the kids at school?
Because I have seen some kids that don't bring money to school who need like extra lunch, and I think it's a really good idea to have like free lunches so they could get like seconds.
And why do they need seconds? Because they get free lunches, and what do they get?
They get extra food.
But what do they get in the first lunch?
They get the same thing, like
4 chicken nuggets.
they get either 4 chicken nuggets or less food.
Thank you. Thank you for letting Charlie speak. So again, we are here to support the free meals. As Charlie said, she sees children firsthand that are still hungry when they get their lunch because they may get a small portion of lunch or 4 chicken nuggets. And these are growing children in 6th grade. They need a little bit more food. But sometimes these are the free lunches. But if they have to buy lunch, they may have to buy a second lunch. And a lot of children don't have the money, and the families don't have the money. And this is a lot of times the biggest meal of the day. We are aware that a lot of children do not have everything they need at home. And so this is an important meal of the day for them. I personally try my best to buy as much healthy food for my children as I can. I have a 19-year-old. He works part-time. He is not ready to go out on his own yet, as part-time minimum wage will not get him out of the house. So we are spending a lot on food. He has aged out of the tax credit, but I want to say that I want to support the child tax credit also because it may help a little bit with some of the other essentials that my daughter Charlie needs, such as after-school curriculum, activities, summer programs, even a tutor. I have submitted my testimony online for both the tax credit and the free meals, so I hope that you will read it. And I really hope that you all will support both of these important issues for our children in Connecticut, because they are well needed for our children. Thank you.
Thank you, Ms. Royster, but I am more interested in asking Charlie a question. Are you still there, Charlie?
Yes.
Charlie, when you're really, really hungry, are you able to concentrate in class?
No.
No, so you're not really able to learn when you're hungry? No, yeah, so that's probably a really important reason why we need to have free school meals. Thank you so much. I see we have a couple of other questions. Representative Lanu.
Thank you, Madam Vice. Hi, Mrs. Royster. How are you?
Good, thank you.
May I ask Charlie a question?
Sure.
Sure. Hi, Charlie. How are you?
I am good.
I want to thank you so much for testifying tonight. Your testimony is absolutely invaluable, and I say it all the time. We need to hear from the next generation, particularly our children and our young people, especially a young lady like you, because the decisions we're making right now is going to take effect for you tomorrow. So thank you so much for being here. Really appreciate it. So I know 7 o'clock at night is not the easiest time, so thank you so much. I very, very, very much appreciate it. Charlie, I just wanted to ask you, you mentioned that, some of your friends and classmates that have free lunch, does their lunches look different than maybe others that can pay for their lunch? Would you, I guess, can you tell by looking at their plate who has free lunch and who doesn't?
No, because when we buy extra lunch, it's like the same portion.
I see. So they have they have a smaller portion? Is that what you're trying to say? I just want to make sure I understand that.
Portion that we get before.
I see. Okay, Charlie, thank you so much. I very much appreciate your answer, and thank you again for testifying.
Thank you, Representative. Don't go anywhere, Charlie. Senator Cohen has a question for you.
I actually just have a comment because I think it's so important for our young people, particularly when we're on the Children's Committee, to be heard. And I'm so grateful for you, Charlie, taking the time tonight to provide your testimony. And I think your points are all very good ones. Talking about needing to get a second meal and how that can be costly when even sometimes a first lunch is very difficult for some people to pay for, and how oftentimes, as your mother pointed out, this could be either the largest meal of the day for some of your classmates or sometimes the only meal of the day. And I think that's really important for us as we deliberate and consider free school meals going forward. So I just wanted to take the time to come on and say thank you so much for participating in the process and using your voice.
Thank you.
Thank you so much, Ms. Royster, and especially to you, Charlie. I think you were the highlight of our evening. If you ever want to come and visit us up in the Capitol, just come on by, okay? Give us a call first to make sure we're there, but we would love to show you around because maybe one day you'll be sitting on this side of the camera or the table. Thank you so much. Seeing no other questions, you're free to go. And next up is Joyce Katslano. Are you still with us, Joyce? Oh, I'm so sorry. Senator Cohen, you're first. I'm so sorry. No?
Do you want me to take over chairing, Representative?
Oh, I'm so sorry. Yes, I guess
No. I just wasn't sure if you were calling on me. My hand's down. I wasn't sure if it was if I was being called on or if you would like me to take over.
Yes, at this point now, we're going to turn over the chair of this committee to Senator Cohen. take it away.
Thank you so much, Representative. And yes, I think we have Joyce Catalano.
Yes, hello, it's Catalano for the record, Catalano, and people just call me Joyce the Voice. So, dear committee members, hi, thank you for listening. I hate to follow after such a sweet girl with my bit of anger about one of the parts. I'm in support of the last few speakers, or perfectly I'm in alignment with. Absolutely, I'm against the part 5 of the 504, the part about putting the names on the list for children who are withdrawn from school. I believe that it's serious overreach of the government from DSF. DFS, I said it wrong, sorry, child support, child welfare. Sorry, I'm nervous and I'm just like blanking out, okay. All right, once a name leaves the system, in my experience, it never leaves the system, and foster care is generational. And it's not just generational in the sense that foster care has, adult has a higher risk of having a foster care child because of the adverse effects from childhood experiences and trauma, and having adult ramifications of that. And fortunately, we just saw a wonderful success story a couple of speakers ago, but they have a higher risk of all different things, of mental health, physical, medical health issues, job security, attachment and relationship problems, jail, substance abuse, suicide, list goes on, and a short life. That's the, there's a huge study on that, adverse childhood experiences, and foster children experience that. And family members experience it as well. The Department of Health and Human Services of New York, of the country, United States, says 83% of foster care children are due to unsubstantiated cases. Then there's also the ghost children who are runaways but are not reported and as missing, and yet by the agency or the foster parents, and yet, or usually group homes, and yet they're still collecting from their Title IV funding. So the gravy train doesn't get disrupted. This is getting worked on, by the way, in Washington, D.C. by a bipartisan group to change the Title IV funding. So this way there's more accountability and liability, because it is a big cash cow. Although the foster families, foster parents do not see that money, and the high turnover of caseworkers don't see that money. So there's accountability problems with the department, and it's broken as far as I'm concerned. Having a list of children that have been signed out of school is not an answer to any.
Excuse me, ma'am, can you please summarize?
Okay, so basically having a list that serves no purpose, it serves no need, that this government cannot be trusted to keep a database of our children, particularly with this, when the government can't be trusted. The system, this is serious overreach when there's 83% of unsubstantiated cases to begin with. Parents are found guilty before proving guilty, unable to prove innocence when family courts arbitrarily decide which evidences are admissible because there's no standard of evidence, and they have no jury. And the Title IV funding, gravy train incentives. So it's a slippery slope to that 5004 Part 5, the lists of sending the names up is very, to the commissioner of DHS, is very, very bad. Yeah, if you're not familiar with the story of baby Sophia Theodoro, I suggest you look it up. You could easily find it on YouTube. I know her mother. She was kidnapped by DHS.
Thank you. That sounds horrific,
Medical
Ms. Catalano.
kidnapping.
So thank you. I
Yes.
do see Representative Dauphiné has a question for you.
Thank you, Madam Chair, and thank you for your testimony today. You gave some information that I've never heard before. I think the 80+% of the foster children
83%.
are there with unsubstantiated cases. Is that what you're saying?
Yes, 83% of the children taken into foster care are unsubstantiated. So parents are guilty before being able to be proved guilty. So they're investigating. They're not always home when they're being investigated. No. And the level of evidence in court is not the same as criminal court or anything like that. And there's no jury.
So do you think that element of fear would be justified with the parents that they're pulling their children out of school and then their names are being notified to DCF? Do you think that that's reason enough to be fearful that their name is even given to begin with for something that
Absolutely.
Yeah.
Yes.
I'm glad you said that. I hadn't heard that, but that's pretty profound.
You could Google it easily. Go to HHS department, DHHS, percentage of kids in unsubstantiated foster care, and then it'll tell you.
Yeah, and I was concerned with Section 5 in SB 6 primarily. I thought initially it was about putting a notification in the chart of those substantiated, but it doesn't sound like that. It sounds like anybody that has had their name sent there for any reason at all, right? It could be a neighbor that doesn't like you that says, oh, your kid was playing outside without any shoes on.
Right.
And then the case just isn't closed, so it's open. And they continue to investigate it. So then that name is coupled in the report with, we pulled your kid out of school. And oh, by the way, just, I think there's a lot of confusion about the Mimi Torres case and the Waterbury case. Neither child was being monitored by DCF. Neither child. So this whole impetus to make this Section 5, they would not have even been identified in that list, if you will. So I'm just trying to make sense out of this policy they're trying to implement. But thank you so much, Joyce, for your testimony today. I appreciate it.
Thank you. Thank you for listening.
Thank you so much, Joyce. We appreciate you being with us today.
Thank you for listening.
Yeah, thank you. Next we have Pam Lakashu. Pam, are you with us?
Yes. Hello. Thank you for having me.
Welcome.
Good evening, Mr. and Madam Chair, members of the committee. I'm Pamela Cashew. I'm the legislative liaison for Teach CT, a statewide homeschool organization. I ask you to amend SB 6 to remove Section 5. I'm sorry. Am I getting a different? There was I was hearing some crossover noise there. Wasn't sure what was going on.
Sorry about that. Please continue.
So I ask you to amend SB 6 to remove Section 5. Section 5 paints with too broad of a brush against a group of citizens who have not been shown to be statistically at higher risk. Hard cases are being used to make bad law. Section 5 violates our constitutional rights by removing the presumption of innocence. As pointed out by the Commissioner of Education, it also violates FERPA. My written testimony discusses the evidence of overall safety and high academic performance of homeschool children. Rather than read that tonight, I'd like to address some comments made today that need to be corrected or fleshed out. First, Matthew Tirado was failed by DCF much earlier than his sister's withdrawal from school. When his sister was first brought to the attention of DCF for marks of abuse, they did not check on Matthew at the same time. When Oak Hill School, the special needs school where he was enrolled, requested multiple times to meet with DCF regarding his truancy, DCF failed to respond. These facts are contained in the original OCA report on Matthew in 2017. I urge you to read that report yourselves. It's time to stop acting as though regulating homeschoolers is the one last step that would save a child when so many cases involve multiple failures of DCF and other agencies over a course of time. The OCA's most recent report demonstrates that after years of interactions with the same families, DCF has been unable to stop abuse and neglect. This failure is borne out by research that concludes that the child protection system is ineffective in stopping abuse. So adding another layer of notification is not the answer. The bill presumes that more eyes on the child in the form of mandatory reporters is the answer. Yet Representative Foster has testified to cases which demonstrate that even mandatory reporters can be abusers. Recent research places the number of children sexually assaulted at school between 10 and 12%. Public schools are not necessarily safer for children. So reporting children who withdraw from public school is dangerous, unconstitutional profiling, and I ask you to amend SB 6 to remove Section 5. Thank you.
Thank you, Pam. I really appreciate your testimony. I will just say that I don't think anybody's insinuating that there's a magic bullet here. And I would say that as somebody who's been on the Children's Committee for almost my entire tenure as in 8 years as a legislator, we are consistently working with DCF to try and improve processes and oversight truly for DCF. So I appreciate your testimony. I think, it's well taken. And I see Representative Dauphiné has a question for you.
Thank you. Thank you, Senator Cohen. And thank you, Pam, for being here today. I know we have a long history together. Like Senator Cohen, this is my 10th year on Children's. I think my 3rd term as ranking, so I'm very familiar. And I look back at the cases, and maybe you can speak to these. The Waterbury case with the young individual, he was in school for 5 years with mandated reporter eyes on him. He had been reported going into garbages and taking food, and people were very concerned, and it never seemed to be hitting the mark with regard to rising up to the level of being an investigation by DCF other than visiting him at home. From what I understand, they visited him at home, and so did the police. And the child said, "No, I'm fine. There's nothing going on here." And they took him for his word, and they walked out the door, and the child was left there for the next 20 or 25 years to starve to death. Mimi Garcia was not being monitored by DCF. She was not a child, but she literally got done school on June 19th. The judicial website says she died on June 19th. I think that's inaccurate and that needs to be corrected. But the reports that I've heard lately are that they believe she passed away on September 19th. So she had eyes on her up until the day she left school in June. So I guess, and I don't mean to be facetious here, but everybody wants mandated reporters all over everybody. So I think maybe she should have had a mandated reporter following her all summer, because she literally died in 12 weeks from when she left school. 12 weeks. The mother reported that she was going to homeschool her at the end of August, and she was, according to reports, she had passed away within 3 weeks of that claim that she was going to homeschool her. So I would also argue that the system never works quickly enough. And I think we had some testimony on that nobody acts quickly enough on any of this. So even if they had gotten to her, she would have already been gone by September 19th if she was starving to death. I don't know, Pam, can you speak to that? I know the constitutional part of this is really difficult for me. Putting somebody on a list, notifying DCF of someone who's done absolutely nothing wrong is just outrageous to me. If you could comment.
Yes, I agree that it is a violation of our constitutional rights, of our right to due process, of our presumption of innocence, and our right to be free of unreasonable searches and seizures, which the collection of that information would constitute. As far as Mimi, it's my understanding that there were other failures for Mimi before the discovery of her body. just to discuss it, is it makes it such a tragic case when one starts to think about what happened to Mimi. It's truly terrible. But Mimi had lived with her grandmother. This is according to the news reports. That's all the information that I have. And was allowed to live with her mother, who had prior criminal conviction, with her aunt, who had prior criminal convictions for abuse. I believe that she lost custody of her children. And then with the mother's partner. So there were other steps along the way that could have protected Mimi. I think that the court case that granted custody to the mom was a travesty. Sections 3 and 4 of SB 6 are a step in the right direction in preventing that kind of tragedy.
Agreed. And I think they're looking at, if you will, preventing someone who's been convicted, and actually she served in jail for, or prison for, risk of an injury to a minor child, and then she went and lived with her sister's children. So I think that that's something that we can definitely look at. That doesn't make sense to me. I know there's been a lot of criticism to DCF with regard to the interview that supposedly Mimi did, but she wasn't being investigated. She was just part of that household. So there was no obligation to do an interview with her. They did everything they could, and it ended up being a Zoom interview, which I'm not saying was good or bad, but if we were going to change that policy, we would have to require everybody in the household to have a, an face-to-face interview. I don't know if that's the direction we're going in, but she wasn't under investigation.
Representative, do you have a question for Pam? I know this is such a devastating case. It's just
Well,
hard to rehash the details of it.
I just wonder. There's been a lot brought up, and I think it's not clear. She was not part of the DCF agency, and neither was the Waterbury case. So I just wanted to clarify that, and I had an opportunity with Pam. Thank you, Pam, for your testimony today. I don't know if you had anything else to add to that, but thank you, and thank you, Senator Cohen.
Thank you, Representative. Thank you, Pam, for being with us tonight. I see no other questions or comments.
Thank you.
Tita Infasang, please feel free to correct my pronunciation of your name.
No, thank you so much. It's perfect.
Great.
Good evening, everyone, honorable chairs and members of the committee. My name is Tita Infasang. I am Senior Director of Advocacy and Partnerships at United Way, Coastal and Western Connecticut. I wanted to thank you for the opportunity to submit testimony in support of school meals for all and a permanent, fully refundable child tax credit. As a member of the Child Tax Credit Coalition and the School Meals for All Steering Committee, we see firsthand how these policies will complement one another. Together, they represent two of the most effective ways that we can reduce child poverty, support working families, and strengthen student success. As a working parent myself in a household with 2 full-time jobs, I know firsthand how quickly the cost of raising a child adds up. Childcare, groceries, housing, and other essentials are really stretching families to the brink, and one unexpected expense can really cause hardship for families. And like many families across Connecticut, we do everything right, play by the rules, and we still feel that pressure. And that's why these policies that are going to lower everyday costs are really important and matter so much to families like mine. Through my work across Fairfield and Southern Litchfield counties at United Way, I see these challenges every single day. We have 42% of our households in our region who are at or below the ALICE threshold, which means that they're working and still struggling to afford the basics. These are families who earn too much to qualify for a lot of programs, including reduced price school meals, yet not enough to cover food, childcare, and housing. We know that 14 to 16% of Connecticut residents are food insecure. That's a 40% increase since 2020, and that Connecticut is now the most food insecure state in New England. And we know that families feel the brunt of this. There's 26% of households with children who are food insecure, and that number is estimated to double in our urban areas and cities. So that's 50% of households with children who are facing food insecurity. No-cost school meals and a child tax credit can tackle affordability from two different angles. School meals really reduce daily costs at school, while tax credits provide flexible support at home. And together, these two policies will create breathing room and ensure children have access to consistent, nutritious food and stable environments that support learning. We think that SB 6 is an important step towards universal no-cost school meals. And we know that when schools are free for all kids, and we saw this during COVID, that participation increases dramatically. This shows that families who don't qualify for reduced price meals need those meals. There's an estimated 46,000 food insecure kids in Connecticut who don't qualify for reduced price meals. A family has to make under $58,000, a family of four, to qualify for reduced price meals. And in our footprint, it is $130,000 to barely survive. That is with no savings, no debt, $130,000. And these families are being left out. We know that limiting meal fees does reduce stigma.
Can you please summarize your testimony?
Yeah. Free meals will save about $1,000 per child. And we really think that the two policies combined can really tackle our affordability crisis. So thank you so much for listening.
Thank you, Tita. I really appreciate your time and your patience and your advocacy around this. I think that's really the goal here, is to, help on these affordability issues and make sure that our children are well fed and not going into a school day hungry or with any amount of shame. So I really appreciate you providing some data and advocating for this.
Yes, thank you so much. And these are policies that are cost effective and we know work.
Great.
Thank
you. I don't see any other comments or questions. So thanks again for being with us.
Thanks so much.
Next, we have Donna Person, followed by Catherine Ororo.
Hello.
Hi, Donna. Welcome.
Hi. Okay. So I have homeschooled my 5 now grown children, according to statute 10-184 for 25 years. I'm speaking in opposition to SB 6 seeking the removal of section 5. Thank you to the members of the Children's Committee for allowing us this platform. Like every homeschool parent, I love children and I hate hearing about children being neglected or abused. Child abuse is abhorrent, and while laws are designed to prevent people, are not designed to prevent people from doing evil, laws can be a deterrent, and they enable prosecution of the evildoer to keep them from continuing their harm. I believe there are many reforms within child protection system that could be enacted that may prevent it. Some of the recent horrific abuse cases in the news. One example is to enable DCF to continue following anyone who has been substantiated for prior or current abuse for the duration of having a minor child in their home, no matter where the child is being educated. No closing cases. As soon as the abuse is paused, they should be subjected to unannounced home visitation. When someone has been convicted of abuse, they lose their right to privacy at a minimum, because that is in the best interest of the child. DCF hiding behind "our hands are tied" is a you problem. Then they should change their policy. In contrast, SB 6 Section 5 would do absolutely nothing to protect children from abuse, as has been already brought up by many others, so I'm going to skip that section. And let's acknowledge that none of the proposals that have been put forth over the years by this committee or the Education Committee, whether to regulate, track, or register homeschoolers, would do anything to protect children. I can supply the data to show that regulation has no impact on the incidence of abuse, if you would like it. But we also know that it would not be effective because that's not the goal of regulation. The goal of regulation is and always has been, and I am in homeschool leadership statewide and nationally for the last 20 years, so I do know something, has been to gain control over the content or worldview that is being taught. I recognize that homeschoolers today are from many diverse backgrounds and hold various viewpoints and worldviews, but we hold in common that we want to do what is best for our children and keep them safe. Data shows that children are safest at home, and trust me, we care enough about children to police our own community. Furthermore, should any of these ill-considered proposals pass, they would likely be rendered completely useless due to legal challenges and implementation quagmire. Finally, these repeated attempts to regulate homeschoolers and homeschooling rob money, resources, and time away from addressing the very DCF reforms that could actually help. When legislators choose to exploit the tragic deaths of children who were failed by child protection agencies rather than using the powers of their office to demand investigation and real accountability and to provide badly needed resources to DCF, you become a partner in the very evil that you're professing to fight, all the while betraying the very children you claim to want to protect. Please amend SB 6 to remove Section 5 and work on strengthening Sections 3 and 4. Thank you.
Thank you, Donna. I might take issue with the fact that we're exploiting these children. I think we're all doing our best to find a better process so that this doesn't happen again. Representative Dauphiné.
Thank you, Senator Cohen, and thank you, Donna, for being here today. I guess, I've known you a long time, and I know you've been around this circle for a very long time, too. I wondered if you could speak to the variety of types of mandated reporters that are amongst your community already. That's something we really haven't heard much about.
Most homeschoolers that I know are involved. Usually they seek community in some way, shape, form, or another. And they are out and about, probably more than, I would say, public school children. They are out in the community. They encounter, whether it's people in the grocery store or, they see people just, they go to, whether it's in church, different groups they're involved with. They have plenty of visibility. I've had legislators, I've heard them say that if they didn't have homeschoolers come to visit them, nobody would visit them. And I believe that's true, so that they, they're out there. And when not everybody I've met a lot of homeschoolers in my many years of homeschooling. I don't always agree with maybe their methods or whatever of teaching their children, but when we always come alongside each other, and that's the difference, is that we come alongside, and if we see a struggle, we're there to try to reach out and help and see what we can do. And if there was something that really concerned us, we're going to report it, because we love children. We wouldn't be doing what we do. I mean, yeah. So I don't know if that answers your question, but
well, and maybe more just expand on it with the different professional people that actually homeschool their kid versus like teachers, nurses. You run into them, so maybe you could kind of go through that list, because
absolutely. I mean, with many. I've been involved with co-ops and different learning experiences over the years. So there's tons of people in all kinds of professional capacities. Our pediatrician for several years in a row would always ask about socialization and this and that. And finally, I just stopped and asked him, I said, are you seeing anything in our children that concerns you? Like, is there a reason you keep asking that? Is there something about them that, that makes you concerned? And he's like, oh no, they're very articulate and I said, all right, well then, and he never asked again. I think it's just people confuse socialization with, I don't know, they use that term, but they never really stop to think about what they mean by that. And I think it helps to just say, well, what do our children are able to function and do very well in society. And there's also data to back that up. So anybody wants to know all the data I'm talking about, I have it in spades. Just email teachct@teachct.org and I can give you lots of documentation. So
thank you, Donna, and thank you for all that you do. Appreciate it. Thank you, Madam Chair.
Thank you, Representative Kit.
Thank you, Ms. Pearson. Sorry here. Thank you, Ms. Pearson, for sharing your testimony. What I'm struck by is you're saying how many people and how many mandated reporters that homeschool parents run into. And I agree. And 99.99% of homeschool parents, I think, are doing a wonderful job. But in your opinion, for someone who's pulling their child out of school, specifically to avoid DCF or law enforcement or further involvement of school mandated reporters, those people aren't. Do you think those people are going to groups like co-ops and stuff if they're actively trying to avoid being found out by DCF? Those are the people we're concerned about, not parents like yourself and others in these groups who are doing a wonderful job educating and socializing their kids. I think the intent of this bill is to make sure that children whose parents are not homeschooling for the right reasons, making sure that those children have there's some sort of tracking or accountability for those kids. Can you speak to that? I mean, how would you suggest, and I'm not being facetious, Chair, I really think we all need to come to the table. How would you suggest that we follow up and make sure we have eyes on the kids whose parents do not have good intent?
I think maybe I'll respond by asking you a question. We know that people that want to do evil, it doesn't matter whether in this case or in any other situation, are going to find a way to do it. Do you really think that in the case of, let's just say, Mimi Garcia, sorry, that if there had been some other mechanism in place, do you think that her mother would have stopped abusing her, or would not have abused her, or that abuse even started at the time that she withdrew that child from school? Do you not think that was going on already for many years, and that whether or not she had to withdraw, whether she had a file or whatever it is that she did, if that mechanism had been different, do you think that would have changed anything? People that are going to do this are going to do it. A piece of paper is not going to stop them.
We're not supposed to answer questions as legislators, but I will say that had Mimi been in school, and it's most likely that she died well before she was actually pulled out of school, or we were told she was pulled out of school. Had she been in school, the weight loss from the starvation would have been seen and would have triggered a DCF investigation. So in that case, yes. But she'd pulled her child out of school before DCF she was pulled out of school well before the effects of her starvation were visible. So in that case, yes, there may have been but again, we're hypothesizing. But in a case where there is frank abuse and somebody pulls their child out before those outward signs of abuse are seen, if there's some it's hard to hypothesize.
Well, people have actually studied this. So if you want the data on it, I'd have to, if you want an actual source, I'd have to give it to you. You'd have to email me. But people that
feel free to email me the source. As a researcher and a public health professional, I prefer looking at the original data. So feel free to send me that resource.
What has been found when they have studied it, and is not a problem of the schools reporting. So schools are mandated reporters, and quite often that has been followed through. When you look at all of the cases, when you look at all the, so that's been followed through. Where the breakdown almost invariably is the follow-up, either a lack of appropriate investigation by DCF or some breakdown in the follow-up of DCF from the report. So it doesn't matter where the reports come from, that always seems to be the weak link that allows the abuse to continue. So I'll just offer that. I don't know if that helps your question.
Well, in this case, actually having that extra report to DCF that this kid's been pulled out could trigger
But if
DCF to do more follow-up.
But if DCF is not doing, if they're already, like in the case of the Waterbury, I mean, over 5 years, they got over 20 reports. So how many more? How many more are needed? You know, like how many more are needed? And if you're trying to then just cast this broad brush of well, everybody that pulls their kid out of school is going to get looked at. If being handed on a silver platter, people that saw a child starving and reported it 20 times didn't get DCF to do something, how on earth is this going to help?
Again, that was over 20 years ago, and we've reformed DCF. But I want to thank you, and you've answered my questions, but I would appreciate it if you sent me your data, because I would like to see the original data. Thank you.
Thank you, Representative, and thank you, Donna, for being with us tonight. I don't see any other questions or comments. Next speaker is Katherine Arroyo.
Did the senator freeze? Oh, no.
Did I freeze? Am I frozen? No? Okay. Katherine, are you with us? Katherine Arroyo? I'm sorry if my connection's not stable.
Hi, yes, good evening. I think you did freeze for a sec there.
Sorry about that.
Dear Senator Meyer, Representative Paris, and members of the Committee on Children, my name is Katherine Arroyo from Waterbury. I'm a parent, former teacher, and a current advocate. As a community advocate at She Leads Justice, I hear from women every day who are dealing with injustices and poverty. I also serve on the Survivor Leadership Committee of the Connecticut Coalition Against Domestic Violence. I urge you to pass Senate Bill 6 because it would create a child tax credit and provide no-cost school meals, breakfast and lunch for all public school children. As a former teacher, I saw firsthand that while academic struggles were real, hunger and unmet basic needs were even more urgent. Teaching for me had also become bringing extra snacks and even extra clothes. The children in our state deserve stability, equal opportunity, and access to basic resources. The cost of living is already overwhelming for many Connecticut residents, over 40% struggling to make ends meet. And for me, court involvement actually became the single greatest financial strain I could have ever imagined. In cases of post-separation domestic abuse, where control and conflict continue after separation, the courtroom can also become an extension of that harm. When these systems are easily susceptible to manipulation, they can escalate conflict, prolong abuse, and push families into financial crisis and poverty. Systems meant to protect families should never become their source of instability. Whether in family court or child welfare systems, once families enter these systems, costs multiply quickly. This is another reason and perspective why any upstream economic supports matter. The $600 child tax credit would help cover essentials such as food, transportation, other basic needs, reducing some stress, increasing stability for families, and strengthening communities as a whole. We must invest early. Prevention is more effective and less costly than pushing families into these structurally sometimes flawed crisis systems after stability is already lost. I strongly urge the committee to vote in favor of this bill. It's time for Connecticut to prioritize children, families, so that our communities can finally truly thrive. Thank you for considering my testimony. And then just listening to the conversation regarding withdrawing children from school, I also wanted to add that I do believe there should be stricter regulations for withdrawing children from school, but while not overstepping on, wonderfully homeschooling parents and the rights that they have. Thank you.
Thank you so much, Katherine. I really appreciate you sharing your story. I know it's not easy, and grateful that you're a part of the process, because yours and so many other stories like yours are exactly why we need to move forward, making Connecticut more affordable, making sure our children are fed, and that we do provide a tax credit. We know that this lifts people out of poverty. So thank you. I don't see any questions or comments for you, but thanks for your time and testimony.
Thank you.
Amari Brantley, followed by Jim Williams.
Good
evening now,
Good evening. Welcome.
distinguished members of the Children's Committee. My name is Amari Brantley, and I have the honor and privilege of serving as the policy coordinator for End Hunger Connecticut. And to be short and honest, what that means is that I lead the School Meals for All Coalition for the state of Connecticut. Today I'm testifying in support of SB 6, an act concerning supports for children and families, specifically Section 1 and Section 2, with the legislation proposed to establish a permanent refundable CT child tax credit and provide no-cost school meals to all public school students. I'd like to just reference something that happened this past weekend. Like all of you, you probably don't want to talk about work on the weekends, but for the first time this session, I got to hang out with some of my best friends. And one of my best friends is a teacher. And to kind of bring reference to its importance, we live in a day and age where teachers, specifically here in Connecticut schools, have to create different code words to kind of enable and assist their children within their classroom. Code words like, hey, go to the closet. Hey, do you need a ruler? Where children and students are able to head to a closet or a specific aspect or a part of a classroom where they might find granola bars or graham crackers that necessarily provide students with the supplements that they need to be able to go through their school day. We know that that's super important because since 2020, since COVID year, we've gone backwards. Throughout COVID, using ARPA funds, we provided students with free breakfast or at least free for reduced price students at the lunch rate. But we see at our last legislation session, we went back. During the challenging times that we're going through in Connecticut, where we're experiencing high cost of childcare, formulas, medical bills, rent especially because I'm 23 and I just, got through that process and can't believe the price that's going on. But for me myself, I'm personally scared of, having a child to deal with these high embracing prices. But across the board, this is a policy that will alleviate families of up to $170 a month. We're looking at $1,700 throughout the year. We're looking at facing rates where over 17% of our public school students are food insecure. Where out of 508,000 students, this policy will feed all of them. We recognize that there is food insecurity as a coalition. We recognize that there is food insecurity in Connecticut's most wealthiest school districts. When we look at one, Greenwich has 3 eligible schools that could participate in the community eligibility provision, but don't. And that's something that we see across so many more communities. This bill will establish a new change for the state of Connecticut. I want to pay respect to a report that was published by the Commission on Women, Children, Seniors, and Equity of Opportunity. It stated that among all of our New England states, Connecticut is the most food insecure. Also involving that report, it stated that out of all of our New England states, we are the state that invests least in feeding our children. This bill, and as a coalition, we believe that this bill is a way that we can change the world, change Connecticut, and change what our schools look like today. I thank you all for your support as you stand to support feeding all Connecticut students. Let's make the investment to fight food insecurity by starting with filling all cafeterias, because cafeterias were built for all students, and currently all students can enjoy the luxury of eating in cafeterias. I thank you all for your time.
Thank you so much, Amari. I really appreciate your testimony and agree with you. The cost of living is just so high. We want young people like yourself and young families to be able to stay here in Connecticut. And I think it's a little bit of a misnomer, right? A misclassification to paint Connecticut with this broad brush that we're this wealthy state. That's sort of the supposition by so many folks living outside of the state, and you accurately point out the level of food insecurity that we have in the state, and I appreciate that so much. I see Representative McGee has a question for you.
Thank you, Senator Cohen. And just a brief comment, Amari, thank you for your advocacy work and your articulate and passionate testimony. It's really profound. One of the most gripping conversations that I had this this academic school year was with a student who saves all their money from birthdays and holidays to pay for groceries. And this student at this age should never have to worry about buying themselves groceries. And so you're absolutely right. You know, what is really a basic, I believe, fundamental human right and a necessity is a privilege for someone like this particular student. So thank you for lending your voice. You spoke for a lot of people tonight, and as a teacher, I clearly see the disparity and deficit in certain communities as it relates to food opportunities. So thank you.
Thank you, Representative, and thanks again, Omari. Seeing no other questions or comments, you're free to go. Thanks again. Next, we have Jim Williams, followed by Deborah Stevenson.
Yes, good evening. My name is Jim Williams. I'm the Government Relations Director for the American Heart Association here in Connecticut. I would like to thank the leadership and members of the Children's Committee for providing me with the opportunity to provide brief comments today in support of Section 2 of Senate Bill 6. The American Heart Association strongly supports funding that gets us closer to healthy school meals for all students free of charge, regardless of family income, which this bill does. You have my submitted written testimony, but what I would like to do this evening very briefly is just to give you some highlights of a poll that recently came out and that we're in the process of ensuring that all legislators have copies of. The poll was a survey conducted online between January 30 and February 6 by the Stats Group under the direction of Dr. Kenneth Dietrich. And it found enormous support for providing students with no-cost healthy meals, as well as a new funding mechanism to pay for it. Some of the key findings include that the vast majority of Connecticut residents support a new law that would have schools provide no-cost healthy meals to all school children during the school day. 93% support this law, and fully 73% strongly support it. 4 and 5 residents are also in support of establishing a state tax of 2 cents per ounce on sugary drinks to help fund a new law that provides the no-cost meals for all students during the school day. Fully 7 in 10 Connecticut residents regard lack of nourishment among Connecticut school children as a very serious problem, and 2/3 say it is a very serious problem that children are not learning how to eat healthy foods. 71% say that some children in school don't receive the nourishment that they need for learning. Support for the sugary drinks as a funding mechanism. The vast majority of Connecticut residents support a new law to have schools provide no-cost healthy meals to all school children during a school day. Further, 4 and 5 residents are in support of establishing a state tax of 2 cents per ounce on sugary drinks to help fund this law. This portion of my testimony most likely will end up residing in the Finance Committee, but I offer it to you this evening only because it's part of the poll and it's offered as a funding mechanism for the school meals. I thank you for your time and be happy to answer any questions that you have now or at another time.
Grateful for your time and testimony, Mr. Williams, and for all your advocacy, and certainly all the good work of the American Heart Association. It's so important that we start these habits early so that and make sure kids are well fed in a nutritious way so that they have lifelong healthy habits. And I just really appreciate all of the information on the poll as well. Is that information, have you made that available through your testimony?
I have sent it to a number of legislators on this committee. I will finish that group this evening, and I know that we have others that are in the process of making sure that each legislator up in Hartford has a copy of that as well.
The other thing you can do for the purpose of this committee is send that to the clerk who can disseminate the information to the committee members.
Sure, I'll do so right after this.
Thank you so much, Mr. Williams. I don't see any other comments or questions. Appreciate your time tonight. Next, we have Deborah Stevenson, followed by, I believe Michelle Gagliardi is not testifying tonight, so Joshua Mitchum will be up after Deborah.
Good evening, Senator. Can you see me?
Yes, I can. Welcome.
Okay. Thank you for having me testify here today. I have submitted written testimony. I urge all the committee members to read it, but for the sake of time, I just want to go over a few points. I am the founder and attorney for National Home Education Legal Defense. It's based in Connecticut. I have been doing protection of parental rights for several decades. And I am tonight testifying against Section 5 of Senate Bill 6. for a variety of reasons. First and foremost, the reason that this section of the bill needs to be removed is because of what the Education Commissioner of the state of Connecticut has testified to, that it absolutely violates federal law and that the Department of Education will not comply. Now, this renders all of the discussion we've had here tonight moot, because if the Department of Education will not comply with giving that information of a student and a family to Department of Education, this part of the bill is meaningless. Okay, it needs to be expunged. It needs to be eliminated completely. Secondly, it needs to be eliminated because the portions of the bill are in complete violation of not only the federal constitution, but the state constitution. And there's reasons for that. This is an automatic reporting of a parent who has legally exercised their right to withdraw from a public school without any reasonable suspicion or probable cause to make a referral to either the State Department of Education or primarily DCF. And in order to do that, then DCF says it will be conducting some sort of search of that parent, and it's unknown where that search will happen, what files they're going to get this information from. Are they going to get information from any other files but their own? It's not known. But the point is, any search without the consent or a warrant violates the Fourth Amendment of the Constitution and a similar provision in our state constitution, and is absolutely unconstitutional and violative of the parents' rights to educate their own child. It also violates other provisions, due process, procedural and substantive due process, and the equal protection provision of our constitutions. And all of the violations, together with the mootness rendered by the State Department of Education in non-complying with it, means that the portion of the proposed bill cannot stand. Now, the other point that I wanted to make, first of all, it removes the presumption of innocence of every parent in this state, and that should enrage every parent in this state. Our system of government does not work like that. We have the presumption of innocence. To automatically report someone who's being lawful removes totally that presumption of innocence and assumes there must be a reason why, even though this was acting lawfully, we must go and search this parent to see it, because they're likely to have neglected or likely will neglect their child. It's absurd, it's outrageous, it's overly broad, it's void for vagueness, it's all sorts of things.
Excuse me, ma'am, please summarize your testimony.
I will indeed, thank you. A couple other points very briefly to finalize this. The information that is collected by this automatic referral and search will be uploaded, if you look at the other sections of this bill, into the now newly renamed P20 system to the data link. And that will be shared among agencies and other unnamed organizations for the purpose of removing legal barriers to the sharing in this interagency data link. And finally, the fourth thing, the committee has no authority at all to adopt this portion of the statute, because the legislature only has the authority granted to it by the state constitution, and that authority has to do with there shall be a public school, all free public schools for everyone, and there shall be a school fund, and you have oversight over UConn. That's it. There is no authority given in our Constitution to the legislature to have anything to do with the rights of parents to educate their own child. For all of those reasons, I urge you to eliminate this portion of SB 6 immediately. Thank you.
Thank you, Ms. Stevenson. I see Representative Dauphinay has a question for you.
Thank you, Senator. And thank you, Deb, for being here today. You and I have talked at length about these cases that have been really out there in the media over the last decade with Matthew Tirado, the Waterbury case with Mimi. And I think that was the impetus for trying to do something like this And I've looked and looked and looked and searched and trying to find where this is going to be beneficial or would have changed any of those cases. Can you speak to that?
Yes, indeed. As far back as Matthew Tirado, that child was enrolled in the public school system and placed in a private school because of autism. That child was known to be also being abused by his mom. His mom was convicted of that and is, I believe, still in jail for that because as you accurately described, only that child was known to have multiple reports to the Department of Children and Families. Department of Children and Families, to their credit, had then filed a petition for neglect against that mother. They tried to then this in the court system, and they ordered her to appear in the court to answer for the allegations that she was abusing and neglecting the child. She never showed up. And what was recorded in the OCA's report at the time was that both the police, I believe, and DCF had gone to the door of Matthew Tirado, knocked on it several times, and she wouldn't answer the door. And so when the judge ordered a capias for the mother because she didn't show up, nobody could get her to, the judge in a I think it was 46 or 96 second hearing, then said, well, we can't make her show up, so, I don't know what to do. So the judge said, okay, case dismissed. And 2 weeks later, that child was dead of starvation. So DCF, a notification that this child wasn't pulled from the public school at all. He still remained in the public school till the day of his death. So going forward to the Waterbury case, again, you accurately described that child was enrolled in the public school system for 5 full years. The teachers all knew about it, that he was being, starved, he was thin, emaciated, whatever, going through garbage, and the teachers brought in food to him. For 5 full years, this was going on, while the principal, to his credit, tried to report to DCF 20 times, child still enrolled, never pulled, and that had gone to DCF and nothing happened, and the poor child was locked up for 20 years till he saved himself. Then finally going to Mimi, same situation. That child was enrolled in a public school, eyes on that child, and DCF had eyes on that child from the day she was born because DCF removed that child from the mother, who was, I believe, in jail when she was pregnant, and immediately removed. And for the next, 10 years or so, 7 to 10 years, she was placed with the grandparents. I don't know what happened exactly to make that change, but there was a change in circumstances. DCF, when a child who has been removed from their parents by DCF, normally DCF is involved in the process when there's a change in circumstances in the family situation and a move to put that child elsewhere. So there is a segment of DCF that works with the courts on these matters, and presumably that happened in this case or not, don't know. But in any case, that child then was placed, ultimately, the last placement was back with the known abusive parent, known by DCF. Open case, closed case, doesn't much matter because this was a change in circumstances of someone with a record of DCF involvement, a record of having removed that very same child from the parent at birth, and yet that child then is dead. None of that would have been resolved had a notice been given to DCF because DCF already knew about all 3 of them. And DCF didn't do anything about it to prevent the child from dying. And that's absurd. And what this legislature is trying to do is solve this problem. I admire that. No child should die. No child should be abused or neglected. But you don't know what the problem is with DCF. What caused all these failures on the part of DCF? Reporting report after report after report, yet the kids are dead or held in captivity for 20 years. Why? Then an investigation of that needs to occur first. Then you need to legislate for appropriate solutions to make DCF better and to protect the children. This has nothing to do with the right of a parent to choose an educational procedure. That has nothing to do with it. This has to do with plain physical, emotional neglect of a child until they're either held in captivity for decades or killed. That is the problem, and this unconstitutional provision is not going to solve that problem at all.
Thank you, Deb. The only one last thing I would ask, because you and I have talked about this too, is that the Constitution in the state of Connecticut says that all those court documents should be open to the public, and they're not. It's not, the Constitution isn't being followed. So you and I have talked about this because we look for some kind of resolution to help these situations, right? To make them better. What's falling apart? We don't know because we can't see the case. We don't know what happened from day one to the end. So maybe you can just speak to that piece as well.
Exactly. In my opinion, all of this needs to be open because in the case of all of these cases, particularly Matthew Tirado, okay, where he went to court. And what court do we go to? We go to juvenile court. Article 1, Section 10 of the Connecticut Constitution says all courts shall be open. There's no ifs, ands, or buts. It says all courts very plainly. And so all of the courts are open except for juvenile court, our most vulnerable kids. And so in the case of Matthew Tirado, if any reporter sitting there, any normal human being sitting there listening to a 46 or 96 second hearing saying, well, she wouldn't show up in court, guess we can't do anything, case closed. Do you think that might have been, enraging some of the public? Do you think that maybe we could have stopped that child in the next 2 weeks at least from dying? I would hope so. Okay, so that's number one with all courts shall be open. I forget the second part of your question now.
I think that we were just talking about resolutions, right? We can't come up with resolutions without knowing what the problem is.
Now
and
I
you
remember.
talked about that over and over again.
Yes, the final thing to answer your question, the DCF itself, the records are not open to anyone other than one person in this state, and that is the child advocate. Okay, so DCF gets to investigate itself when these problems occur because they're asked to, because nobody else has asked for an outside investigation. So DCF investigates itself. Well, what was the problem? Then they give a report to the one person in the state who can look at the records to verify whatever DCF is saying, the child advocate. And the child advocate won't show the legislature even. At least the legislature should have access to those records to verify what happened here so they know what to do about it. But that has not happened. So those two things, transparency, opening up the courts like they're supposed to be open according to the Constitution, and opening up the records. Now, albeit you need to give due process to the accused. So when the investigation is finalized, like it was with Matthew Tirado, the mother was convicted, those records still have not been made public to anyone. Why? What happened there? Okay? They're not open, and the OCA is fighting to keep records closed. We have a Freedom of Information Commission appeal of a denial of the records for just the OCA's report, not anybody else. And they're fighting us on that. Why? I don't know.
Oh, I appreciate that because I'm always looking for resolutions as well. And I think that's a big one. I don't know how you fix something that's broken unless you know what's broken. You have to look at the case and say, okay, what happened here on this day, and this day, and we can't see it. So thank you, Deb. Thank you for coming out today and testifying. Appreciate it.
Thank you.
Thank you for your testimony, Deborah. I'm now taking over as chair for the next hour, and I just want to remind everyone to limit their testimonies to 3 minutes, and each member has 2 questions, especially in consideration of time. Does anyone else have any questions for Deborah? Thank you for your testimony, ma'am, and thank you for hanging in there with us.
Thank you.
Next up, we have Joshua Mitchum.
Thank you, Representative McGee, members of the committee. My name is Josh Michtam. I am a senior attorney at the Center for Children's Advocacy and the director of the Child Welfare Project at the Center for Children's Advocacy. I have been representing parents and children in child welfare cases for over 18 years. And I've also taught related subjects at Quinnipiac Law School and at UConn Law School. And my work has submitted more extensive testimony, but I really want to focus on House Bill 5004, which has many good things in it, but specifically on the Policy and Oversight Committee that's in Section 20 of that bill. I think that's a good thing. I think, as we've heard from the person who testified before me and from many people, there is a real need for independent oversight of the Department of Children and Families. And what I want to focus on is that a Policy and Oversight Committee is only as good as its members. And I think there is a group of people missing in the statute as it's written from that committee, and that is representatives of the lawyers who represent the parents and the children in these proceedings. The lawyers have a unique role because we are repeat players. We see many cases unwind. Sometimes we represent a child and we're aligned with DCF. Sometimes we represent a parent and we're adverse to DCF. But most importantly, we are independent from DCF, right? Many of the folks who are named as going on this oversight committee, either they are representatives of the department or they're folks who are clinicians who work for a service provider that has a contract with the department. And that's not to say that those members won't do their best to be honest in their oversight of the Department of Children and Families, but fundamentally, an agency can't oversee itself effectively. And we need, what's more, the insight of people who deeply understand this system, who see what are the flukes, what are the one-off weird cases, and what are the trenchant, repeated problems. And I will say, because I'm in court nearly every day representing children now, that the state of the provision of child welfare services is in crisis right now. Between the turnover of staff, between the lack of adequate mental health services, the lack of adequate placements for children, the long wait list for services for parents, we are in crisis. We are not doing well on national benchmarks against other states, and it harms our children and it harms our families. And I don't mean to suggest that DCF isn't doing its best. I don't think there's anyone of ill will or who's lazy in that whole department. I consider the interim commissioner a friend. She's a former colleague and boss. But any agency needs truly independent oversight and informed oversight. And I would suggest to you that if you ask nearly any lawyer who is practicing in our juvenile courts now, they will tell you that many things are going wrong that need to be addressed in a not just little by little, but in a transformative way. So I would urge you to make sure there are representatives of the attorneys who represent parents and children. And by the same token, in Section 13, the working group that would say what data DCF has to share, you want those folks there too, because this is a complicated system. It is closed courts. Most people don't know how it works, and you need independent experts in the room. And I will stop there in case I see there are questions.
Thank you for your testimony, Joshua. Representative Wielander.
Thank you, Madam Chair. Thank you for being here, Joshua. And I was wondering, would you be able to, I should say it like this. Do you think that the chief court administrator and the probate court administrator, they wouldn't fill those roles in having a broad understanding of the court process?
I think the chief court administrator more. The probate, I mean, I don't want to speak to any individual who may or may not have particular knowledge, but I think the particular work of both litigating in the juvenile court as opposed to seeing the probate court and visiting with the clients, right? The lawyers are out there, they're in the homes of children, they're seeing foster homes, they're seeing group home settings, kids who are in hospitals. They just have a wealth of knowledge, repeated case after case after case. that is irreplaceable and absolutely necessary.
I appreciate that feedback. That is something that we've heard in different hearings on different bills, that the need for linking together the family court system and the process and trying to sort of look at it as a whole. So thank you for bringing this to our attention. I appreciate your time tonight. Thank you,
My
Madam Chair.
pleasure. Thank you.
Thank you, Representative. Senator Mar.
Thank you so much. Also appreciate your testimony. I would love to know when, and I was looking for the makeup of the oversight committee, and I can't seem to find it here in this document, but I'm curious, when you stated that you feel that it's important to have an oversight committee, but I'm uncertain as to what you saw was the best makeup, because what you referenced was social workers who worked for DCF or people that were engaged with DCF who might not have the, perhaps they would have the knowledge, but not the distance to have oversight. So I'm just curious, what would you see as the makeup of a committee like this, based on your experience?
Thank you, Senator Mar. That's a great question. I mean, and I want to say, it's not that I think that the folks who are named in the proposed bill shouldn't be there, right? I think obviously you need all of those folks, but I do think you need, I would say, you're asking me to draft legislative language on short notice, but in attorneys, attorneys with some amount of particular amount of experience in representing children and families in the juvenile court, advocacy. I mean, let me be transparent. I think Center for Children's Advocacy should have a seat there too, because not only are we those attorneys, but we also do a lot of other work that's related across fields that affect children. But I do think that you should have an attorney of long experience in this field and an advocacy organization of, decent reputation.
Okay. All right. Thank you so much. Appreciate you being here and waiting and to give your testimony.
My pleasure.
Thank you, Madam Chair.
Thank you, Senator Mar. Does anyone on the committee have questions or comments for Joshua? Seeing none, thank you for your time, your testimony. Oh, he left us. Moving on to Gail Shanley. Gail Shanley. Okay.
She's not here right now.
Okay, thank you. Moving along on to Tanisha Signor. I hope I said that correctly.
It's Tanisha, but I think Diane Connors was before me, and I see her on the screen.
Oh, I'm sorry. I'm sorry. I skipped you, Diane. Take it away.
All right. Hi, I'm Diane Connors from Connecticut Homeschool Network, and I am here in opposition to Section 5 of SB 6, which would require that data for every student withdrawn from public school be released to the Department of Children and Families, regardless of the reason for the withdrawal and regardless of whether there has ever been any allegation of abuse, neglect, or prior DCF involvement. This is not a narrowly tailored child protection measure. It's a blanket reporting mandate that treats every withdrawing family as a matter of suspicion, and that's concerning. Withdrawal from public school occurs for many lawful and ordinary reasons: career or military relocations, private school enrollments, medical needs for the child, safety concerns when the children are harmed in the public schools, and choosing a better academic and educational fit, which includes homeschooling. Yet this proposal does not distinguish between those circumstances. It applies suspicion universally. That approach creates a presumption, not based on evidence, not based on individualized concern, but based solely on a parent exercising a lawful educational choice. Notably, as mentioned already, the Commissioner of Education has testified that Section 5 would require disclosure of confidential student records in ways restricted under federal FERPA law, potentially jeopardizing millions in federal funding. When the very agency directed to carry out this mandate states it cannot legally comply, that is not a minor concern. It is a strong evidence that the provision is indeed fundamentally flawed, however well-intentioned it might be. SB 6 also expands and renames the state's integrated data matching system, DataLink Connecticut, which is designed for cross-agency data matching and integration. Yet Section 5 contains no explicit limits on what withdrawal data is transmitted, retained, or prohibited from being integrated into broader data systems. Now, specifically in the homeschool community, this is of concern because we have FOIA documents where it was questioned about wanting to get homeschooled kids in the PSIS system, which now has been renamed. So this isn't just a concern that we have, it is a valid experience that we have witnessed. Additionally, recent public statements suggesting that Connecticut is among the least regulated homeschooling states do not accurately reflect the national landscape. This is important. States such as Vermont and New Hampshire, as well as others, have recently reduced homeschool oversight requirements, and Connecticut's framework aligns with the majority of states nationwide. Characterizing our state as an outlier misstates reality and risks justifying.
Excuse me, ma'am, can you please summarize your testimony?
Yep. It risks justifying regulatory expansion. So the bottom line is there is no data showing that this is going to cause improved safety measures for children. It just doesn't exist, and it's just not the way to go. Are there any questions?
Thank you for your testimony, Diane. I see that Rep. Dauphiné has a question. Go ahead, Representative.
Thank you, Rep. McGee. I appreciate it. And thank you, Diane, for being here today. And I know you and I have spoken many times, and I just wanted for you to share, and I asked Donna Pearson this earlier. We've talked many times about the variety of homeschool families that are out there, their exposure, and the mandated reporters among them. Can you just share with us your experience? I know one of our senator chairs earlier said that she thought it was important that mandated reporters had their eyes on all of these homeschooled children. And I would probably just want to mention again that Mimi Torres got done school on June 9th, would not have had a mandated reporter looking at her throughout the summer, and died right when she was supposed to go to school again. So it was over the summer that she was starved to death. I'm not sure where we're going with this, if we're looking to have a mandated reporter looking at every child all year round, 12 months a year. But can you just speak to the mandated reporters that you know that are among homeschool families?
Certainly. First of all, in the homeschool community, there are very many public school teachers, some of them with doctorates in education that are homeschooling because they have seen what's on the inside. And that's not me talking, that's them talking. They're mandated reporters. There are many social worker moms or dads that are mandated reporters. As we have heard earlier this evening, there are also many foster parents that are homeschooling their own children while doing foster care. They're mandated reporters. And the homeschoolers, I mean, there are many others. There are therapists, you know, there's just people that are in clergy that are homeschooling. The mandated reporters are everywhere. Excuse me. So homeschoolers typically are involved in co-ops. Their children do their academics, which is, you know, usually in the morning for a few hours and you're done. And in the afternoons, that's when you're usually doing co-op classes once a week or twice a week, going to supplemental classes, perhaps taking karate or a guitar lesson or going ice skating, going to many library programs. Lots of times homeschoolers will meet in the library, more mandated reporters. In the co-ops themselves, a lot of the parents that teach the classes in the co-ops are mandated reporters. They're everywhere. And when we met with DCF during the summer, during a working group, and there were people from DCF that were present at that meeting, and they said that 47% of the calls into DCF come from the schools. So that's 53% that come from the community at large. And I know there was a statistic mentioned earlier by, I think, Quinn. That was incorrect based on what we were told directly in a large group of people. So I think I answered your question. I mean, it's really diverse, and our kids are out and about like all the time.
Yeah. And I thank you for that. And I know that we're, we've been here a long time, and I don't want to just keep adding on here, but just one other sentiment you could share is, I remember when we learned of Mimi, and even prior to that, the Waterbury young man who did what he did to get out of his home. Can you just in a couple words share how the community and the homeschool community felt about the outrage of what had happened to those children?
Well, of course, it's a tragedy. Everybody is shocked, and you go through the emotions of that for any child because it's horrific that anybody could do that to a child. But it's further complicated when you're innocent and you're accused repeatedly of being guilty or suspect of something that you had no part of at all. And that's what is so disturbing about this Section 5 of SB 6, because it is a blanket reporting system, and it isn't going to solve anything. We have to all of us in Connecticut need to be really careful that we don't overlook what the real problems are, which Attorney Stevenson was mentioning earlier, and the other man that was just speaking. If we don't really fasten our seatbelts and look at the core issues of what's really, really wrong, there's going to be another tragedy.
Yeah.
There are 9 million homeschooled children in America, and we don't hear these kinds of stories hardly ever. And I know there is a nationwide organization that has followed up on some allegations of wrongdoing with children, and virtually 100% of them had public school connections and child protective service connections every single time.
Yeah.
So, just because somebody says, oh, homeschooling, let's face it, Mimi's mom did not have a curriculum for her. She was either already gone or shortly thereafter she was gone.
Right.
Not homeschooling, it's subterfuge. We're innocent and we're being blamed for something that we did not do. And so targeting this community and not looking at the real problem is assuring it's going to happen again.
Yeah. Thank you, Diane. I really appreciate you hanging out with us and testifying. I appreciate it. Thank you. Thank you.
Thank you, Representative. Any other questions or comments? I just want to briefly say, Diane, thank you for your testimony. And the one thing that I love serving on this committee is there are dedicated, passionate people who really do care about the safety and the protection of children. And so I know that the intent of this committee is not to target or attack anyone, but to really create meaningful legislation and conversation that makes sure that we ensure like a safe Connecticut for all. And that's looking into every equitable solution or idea we possibly can. So I thank you very much for your testimony. Thank you for waiting it out with us tonight, and I hope that you have a great night.
Thank you.
You're welcome. And now we'll have Tanisha. Now it's your turn. Take it away.
Hi, thank you, Rep. McGee. Good evening. my esteemed members of Connecticut General Assembly's Committee on Children. My name's Tanisha Signor, and I'm the Policy Director at She Leads Justice, a statewide nonprofit that uses a justice and equity lens to advocate for under-resourced and marginalized women in Connecticut. I'm here to testify in strong support of a Connecticut child tax credit as well as no-cost school meals. And I'm going to begin talking about the fact that Connecticut has a regressive tax system and that our low and middle income families are overburdened, and it forces them to pay a larger portion of their income in taxes than those earning the most in our state. And this is an unfair reality. Alice data from the United Way tells us that a survival budget for a family of 4 in Connecticut is $116,000, $116,208. This means it's for the essentials only, right? For a family of 4: housing, childcare, food, healthcare, transportation, etc. According to this data, 40% of families in Connecticut are struggling to afford the most basic needs. I know you guys are going to hear that data said a lot. 40% of families in Connecticut. Everyone who testified about a child tax credit today probably mentioned it. But I really want to give you guys a second to let that number sink in. The data is telling us that almost half of the families in Connecticut are grappling with hard choices every day and trying to stay afloat. Parents might be skipping meals or doctor's appointments. Cars are going unmaintained. Prescriptions might be getting stretched to the limits. And most importantly, parents are losing time with their children because they are forced to work multiple jobs. Inflation is overwhelming and wages are not rising sufficiently. Establishing a child tax credit in Connecticut would not be a cure-all, but it would be meaningful and a useful gesture. We know that these are powerful, proven tools in fighting child poverty. We know this especially because of when the American Rescue Plan was enacted in March of 2021. It brought child poverty levels to historic lows. And when we shuttered the pandemic relief, the rates of child poverty quickly rose back to pre-pandemic levels. This child tax credit would reach over 550,000 children in Connecticut and allow them to thrive a little bit more than they are right now. Additionally, the gender pay gap is persistent in Connecticut and around the country, and many factors contribute to this. The reality is that women are more likely to be responsible for unpaid care work at home, and in general, we are earning about 81 cents to the dollar for every dollar earned by men. But the disparities are greater for women of color and women who work multiple part-time jobs. A fully refundable child tax credit would benefit 87% of female-led single households in Connecticut, single parent households in Connecticut, providing dependable, much needed funds to the women who keep our state's economy running. A child tax credit would also do a lot to address the racial disparities. We have the second highest level of racial income gap in the country.
Can you please summarize your testimony?
Absolutely, I'd be happy to. Thank you. Establishing a child tax credit in Connecticut and investing in no-cost school meals for all children would be an amazing contribution to the working families of our state. We really hope that you'll consider these parts of SB 6 and the testimony that you've heard today. Sorry. All set.
Thank you for your testimony and your advocacy, Tanisha. Does anyone have any questions for Tanisha? Thank you for your time. Thank you for spending your evening with us. Have a good night. Next up, we have Drew Michael McWeeny.
Good evening, Children's Committee. My name is Drew Michael McWeeny. I'm an assistant professor of early childhood education at CT State Community College, Norwalk, and I'm the program chairperson for the early childhood department, as well as a PhD candidate in education at University of Hartford. I support SB 344. However, I would like to take the time to share my thoughts about SB 6. So first, the refundable child tax credit in this bill. I believe that it should be adopted, and I support the idea because it provides direct financial assistance to families raising children, especially those single fathers like me who are struggling but working hard. And ironically, I'm a full-time state employee, and I'm still struggling. And also, ironically, we hear the word the wealthy, right? They get all kinds of tax credits and deductions. So I wonder why, they seem to be complaining about someone like me getting the same exact tax credit as they are. The only difference being is that I have kids and it's a child tax credit. We know that Connecticut's the richest state in the United States, and we know it's just an expensive one. But as someone like me who has custody of my two girls, there's no second income in my home. I don't have an ex that helps contribute, unfortunately. Every bill rests on my shoulders, and when you're the only provider, every dollar matters. So just want to be clear that I'm not asking for a handout, because contrary to some, I work hard, I budget carefully, I sacrifice every day. And even when I do something right, I still feel like I'm one unexpected expense away from falling behind. So I really think that a child tax credit would put real dollars in my pocket to use for my kids. Sometimes the only way people have money to spend in order to stimulate the economy is they work to earn a paycheck, and most times getting a paycheck is simply not enough. I don't really see this bill as a handout. Although I'm still struggling with the fact that all of this is paid for through tax dollars. And I agree with that argument. I'm paying so much in taxes. I'm struggling. So there's got to be a better way to fund this this tax credit without having to hit the taxpayers even more, because I'm a taxpayer. I think preventative investment is fiscally responsible. And I do every day as a single father, I try to be fiscally responsible and raise my kids. So I'm asking the state to do its part as well. Help single households like me be financially secure until we're able to not have to rely on, such assistance. And I do think refundability should be given to everybody. This is a matter of equity, and equity means it's given to everybody, not just a specific demographic, not just to those who are struggling. And then finally, quickly, in regards to Section 5, the fact that the Education Department has to report to DCF about children withdrawing from school for homeschooling and all this stuff, it's a gross breach of abuse, and I think it's a form of bullying. So I think that it's crazy that that's even being proposed. But again, that's not my wheelhouse, but I believe that the same people who complain about homeschooling are the same people that claim, well, parents know best about their kids. So I just think this whole section's hypocritical. I stand with those families that are homeschooling their children to the best they can and are honest about it. So listen, thank you for letting me share my thoughts about this, and to the best that I can, and I would be more than willing to answer any questions you may have. Thank you so much.
Thank you, Drew. I see that there's a question from Rep. Mastro Francesco, followed by Rep. Dauphiné.
Thank you, Madam Chair, for your giving me the indulgence here. Thank you, Drew. I get to see you twice today. I saw you testified in our Labor Committee. A couple of things. One, I agree that, a tax credit for everybody would be wonderful. I think that we are overtaxed in Connecticut. It's a burden on everybody, not just a few. We always seem to hear that, we're only going to get a tax credit for certain people. And I agree with you, this should be blanket. Everybody works hard and everybody should get it. So I agree with you there. You had mentioned in your testimony, you didn't really elaborate on it, about Senate Bill 344. So I'm not really sure where you stand on that. Can you just elaborate on that? You said you supported it, and I just wanted to kind of hear your thoughts.
Yeah. So I'm in full support of it. Look, I'm not exactly sure what the whole point of the bill is, considering there's already mechanisms in place where school districts will ask. I know, for example, as a student teaching supervisor, at the beginning of the semester, at the initial triad meeting where I meet with the student teacher and the cooperating teacher, I give them a permission slip that they need to send home to families, even though the school district does that too, that asks families for their permission for kids to be used for social media and all this stuff. So there's already mechanisms in place for this. So I'm not exactly sure why this bill is even proposed, but I support it, because if I don't have that choice to be able to check off that line that says no, I don't, if someone's going to take that, parental thing away from me, then I think it's an infringement on my rights. So I'm in favor of getting permission from families to be able to make those decisions in regards to children's right to privacy.
Okay, yeah, thank you. It's interesting. We heard a lot of testimony today through you, Madam Chair. We heard a lot of testimony today on Senate Bill 6 and a couple other bills, but I haven't heard a lot on Senate Bill 344, which obviously you do bring up a good point. And there are mechanisms in place already. I know in the school that parents need to sign off on a paper to have their child photographed or used in any type of media. I'm not really sure where they're going with this and how this one is different, but I guess that remains to be seen. And then your comments on the last section 5. Do you being an educator, have you experienced students, and I'm not sure what grades you taught, not enrolling in school or being removed from school? Have you had any experience with that at all?
Yeah, and I taught special education, infants, toddlers, and preschoolers. So I did a combination of integrated, worked in the autism room, but a lot of work with the severe and profound. So the kids that were at Connecticut Children's Medical Center, I would service them half the day. They'd come to my classroom. So I haven't had any experience with any parents removing kids from their from public education per se, but I do know many people that have purposely not put their kids in public schools because for some reason, and don't ask me because I don't really pry into that stuff because it's their choice, but I'm finding largely that the reason why that they're pulling their kids from public schools because they don't philosophically agree with what is being taught.
I gotcha. Yeah.
So that's the only real experience that I have when people are, families are not sending their, and it a little bit hurts me because I've worked in the public school. I'm training teachers, educators from birth to elementary school to go into the classrooms and do this type of work. So yeah, I'm a little hurt knowing that there are families out there that are making that decision, but on the same aspect of it, as a single father myself, I believe that I can't imagine that, a single parent like me that has to make that decision. I can't see why, that isn't considered seen as a sacrifice. I would think that, I should be able to look at every family and assume, that they have the best interests of their kids in mind, without having to pry further. It's the same thing as running a building as a school, as a principal. The only way, and I teach this in my evaluation supervision course, just a little anecdote, not to oversimplify my argument, but, I tell the administrator candidates, the only time you micromanage is if you get information that shows you that there's something not being done. So in other words, you treat all of your teachers as if they're doing their job, leave them alone, let them thrive, right? I believe the same way when it comes to families, because I'm a parent. Let them we're going to assume they have good intentions. Let them do what they need to do. If they fail, it's on them. They need to troubleshoot. They need to problem solve. They can come to us for help. Absolutely. As a teacher. Absolutely. But that's my mindset is we need to, treat them equally. Again, that equity, right? And know that they're going to make the decisions and they have reasons for why they do that. Why should anybody have to be responsible for answering for other people's decisions? So I'm hurt when they pull them out of public school because I believe in public education and I know what it can be. And I know I'm trying to do the good work to train them to be able to, reach families and stuff. But at the same time, I understand it because I'm a parent. I'm doing it all alone. And I don't know, there may be a time and place where down the road, maybe I'm not liking it and I pull my kid from. So I don't want to get judged. I don't want to judge others when there's a possibility for them to judge me because I'm just doing my best.
Thank you. Thank you so much for your testimony, Drew. I appreciate it. Thank you, Madam Chair.
Thank you, Representative. There are 2 more questions and brief comments. Representative Dauphiné, followed by Rep. Wheelander.
Thank you, Representative McGee. Appreciate it. Thank you for your testimony today. I learned a little something from you. I appreciated you talking about, you were really putting it in the context, the child credit for hand up, not a handout. And I really appreciated that because that is what you would hope that this would do, right? What would you say to the people because I hear a lot about picking winners and losers, and trust me, I'm the first one that will say our taxes are way too high in Connecticut. But we have the elderly and other groups of people that are struggling too. What would your comment be to them? What would you say to them?
can you clarify or rephrase for me so that I can
I'm-
answer it?
So I know
honestly?
that you said that it's very beneficial to people like you, single parent, have children, hand up, right? So that you can do better and succeed and not need it, right? I get that, and I like that. It's what we would hope for everybody. But for a lot of people, I hear, we give. What about these struggling elderly or the homeless veterans or this or that? What would you have a response to that?
Yeah, my response would be the same thing. Equity means fair. And in order for us to achieve fairness, we need to apply it to all demographics. It's not just those single fathers. It's people like me in that situation that need it. If we have elderly that are struggling, there need to be ways that we can help them. That's what fairness is making sure that all of our demographics, all of our populations are able to have that support. I think that the state government needs to look at the expenditures and cut the waste so that we can take that waste and put it towards things that are meaningful and relevant, and that might help ease the burden of the taxpayers. But I also think, Representative, that something to worth looking for is how can we fund these things without hitting the taxpayers? We can do it through endowments, we can do it through philanthropies. I know for a fact, as a recreation consultant, I have an LLC, a business. I'm donating my time, my services, my money that I earn to the community because I believe in the community, and in return I get the tax write-off. So I'm benefiting myself by tax write-off legally, right? But also I'm giving back to the community and helping. So that's how I would respond to that is if we're not making every demographic, comfortable, whatever that looks like, we're not doing enough. That's how
I love that. And I think it's a great idea. And I always think that we look to the government for answers for everything instead of, like you're suggesting volunteering in your own community and participating in that way. So I appreciate that. And then your comments on SB 6 Section 5, I appreciated that you were really pointing out that the individuals that are, we're kind of presuming them guilty before, instead of innocent before guilty. And you kind of laid that out nicely. So thank you. Thank you for testifying today. I appreciate it. Thank you, Madam Chair.
Yeah, I just,
Thank you, Representative.
to answer to respond to that, I'll admit I've made mistakes in my life. I will totally admit that, but I am not one to judge other people's decisions.
Thank you, Drew. Representative Wieslander.
Thank you, Madam Chair. Thank you, Drew, for being here tonight. I just you mentioned Senate Bill 344, and just wanted to clarify that because we have so many different local boards of educations, and especially when we're looking at charters and magnets, RESCs, all of these types of educational organizations, many times they have individual policies regarding using likenesses of children in their schools and their outreach and such things like that. So this would just be a little bit more uniform and make sure that we are asking parents to acknowledge directly that the schools have the permission to take a photo or a video of the child at field day, on a field trip, whatever it is, that is just a little bit more direct and explicit, rather than just one, I consent to my child being photographed type of thing, or just my child may participate checkbox that also includes social media usage and images and likenesses, because once it gets out on the internet, it's there forever. So just wanted to clarify.
Yeah. I still am in support. I still am in support of it. I think it's fantastic.
Okay. Thank you so much. I appreciate that. Take care. Thank you, Madam Chair.
Thank you, Representative Wieslander. Any other questions or comments for Drew? Thank you for your testimony and your time. Have a great night, Drew.
Thank you.
Up next, we have Angelica Espada.
Thank you, Representative or Madam Chair, and everybody in the Children's Committee. Today I just wanted to testify for Senate Bill 6. I agree with a lot of the sections in this proposed bill. However, I strongly oppose Section 5. As a homeschooling mother, I just want to say that for nearly a century, the Supreme Court of the United States has been clear. Parents, not the government, hold the primary responsibility and authority to direct the upbringing and education of their children. And this is not a fringe view, it is a principle woven deeply into our constitutional fabric. Um, in Pierce versus the Society of Sisters, the court, which was really, far back, the court declared that children are not mere creatures of the state and struck down a law that tried to force every child into public school. And the justices affirmed that parents have the right to choose the educational environment that best fits their child's needs. And that ruling alone is the backbone of modern homeschooling freedom. Before that, in Meyer versus Nebraska, the court protected the right of parents to determine what their children learn, striking down any restrictions that interfered with family choices. And later in Wisconsin versus Yoder, the court reminded us that deeply held values, educational, cultural, and religious, cannot be overridden simply because the state prefers a one-size-fits-all model. And these cases remind us that government oversight must be reasonable, limited, and respectful of family autonomy. Today, as more families choose homeschooling or other alternative paths, some call for increased government involvement, but we must remember why these rights exist in the first place. Parents obviously do know that their children more intimately than any state agency. They're the ones who see the struggles, talents, their fears, and their potential. So a parent's decision to withdraw a child from school environment is often an act of protection, not neglect, an act of responsibility and not avoidance. So not every child will thrive under the same structure, and choosing homeschooling is not an escape from responsibility. It's actually the embrace of it. To equate withdrawal with wrongdoing is to misunderstand both the law and the heart of parental duty. Homeschooling is legal in every state and supported by decades of Supreme Court precedent and rooted in a fundamental liberty interest recognized by our highest court. So the question is not whether the government can educate children, it is whether it must. And the answer, resoundingly affirmed through our history, is no. Parents have the right to choose, and that right deserves our steadfast defense. And just to wrap it up, in regards to all the tragic cases, I don't think it's right to broadly paint us all as neglectful or that we will be neglectful, because, that's not how due process is properly done. So, and furthermore, I do have a real concern that with this list of data that would be collected, will this later be an increased regulatory authority or additional reporting requirements? Would it risk shifting that balance towards government overreach? So what I mean by that is surrounding discussions regarding HB 044, which is pending legislation, possible legislation, and the possibility of combining that expanded oversight with the registry tied to a vaccine mandate for all residents, and basically just expanding into centralized registries that track families, particularly when linked to educational status or medical decision. And it raises serious privacy and civil liberty concerns. So combining or cross-referencing them could create a precedent that erodes the boundary between parental authority and state control. Even if well-intended, such measures risk unintended
Hi, ma'am. Can you please summarize your testimony, please?
Yes, ma'am. Including data misuse, discrimination, chilling effects on families who choose lawful education alternatives like homeschooling. So I respectfully urge you to protect our homeschooling freedoms by, yes, supporting SB 6, but please remove Section 5.
Thank you for your
Okay,
testimony, Angelica. Does anyone on the
Thank
committee have
you.
any questions or comments? Seeing none, thank you for your testimony and have a wonderful night.
Thank you.
I do not see Christina Dustin, but I do see Steve Kennedy. I believe Steve will be rounding us out, but before you take the floor, after your testimony, I am turning this public hearing back over to Senator Marr for
Excuse me,
closing.
Madam Chair. I believe that we have promoted number 45, Gail Shanley, who had not been here before, but now she is. So I
Okay.
wanted to reference that. Thank you.
Okay. So we will have 45. Okay, so we'll have Steve because Steve's unmuted and ready to go. And then Gail, you can close us out. Thank you.
Sure. Thank you, Madam Chair, and to members of the committee. It's hard to kind of see who all's on here, but thank you all for hearing from me. I'm a lawyer and organizer in Newtown, and I'm also a homeschooling parent to my 4 children. First, my apologies for uploading the wrong document to my written testimony. I sent the correct one to Mia, so hopefully that will be uploaded soon, so you can reference that if you'd like. But in the bill that's actually before you, I'm here actually in support of SB 6. In the bill that's actually before you, I don't see any attack on homeschoolers. There's been a lot of talk about witch hunts and treating us like we're innocent until proven guilty and all of that, but that's just not what's happening here. There are organizations and legislators who really benefit, I think, from keeping homeschoolers feeling like we're constantly under attack and isolated regardless of what is actually happening. But I think even that if you are worried about some kind of deep state surveillance or something like that, a pretty simple addition to this section stating that the notification is not to be retained by DCF or something similar should be a pretty straightforward solution. I have a feeling that wouldn't really satisfy these organizations, but because again, everything is a big government plot and the state is always targeting us and out to get us. But as a homeschooling parent, it's bad enough to me that abusive parents are using us as shields to hide their abuse. And almost even worse is the idea that my supposed right to not exist in the government's eyes outweighs a child's right to be safe in a supportive home. And we can't say that DCF is the whole problem and it's not a homeschooling problem, and it's not a homeschooling problem. But like when we constantly are putting ourselves in the way of any minor fix to the way that DCF can do its job, we're making it about ourselves. And don't get me wrong, I mean, I'm not here to like cape for DCF or something. Josh Mictum testified earlier, and he's someone I trust completely on these issues. I really hope you take his testimony seriously on anything related to DCF. I'm always concerned about increased DCF involvement when it comes to homeschooling because of the way that it's, the agency can be weaponized against families, particularly against poor families, families of color, who have often left schools because they're not properly serving their children. But here we're not talking about a mechanism that would start any new investigations or public reporting, but we've got attorneys out here telling homeschoolers that they're going to end up on a watch list that's going to show up on background checks when you apply for a job. When this is a bill that just does not do that. And I feel like an extreme version of parental rights doesn't outweigh the rights of children who don't have parents ensuring them at home. So I was sexually assaulted as a child, and I can't imagine how much worse that would have been if I were in a situation where my parents had deliberately isolated me from anyone who could help. But here we are like 4 levels deep in what ifs about homeschooling watch lists and secret investigations, when statistically speaking, there's a kid locked in their basement somewhere in Connecticut right now. And not everything is a conspiracy, and not everything is about us as homeschoolers. Like, this is a minimal measure that could have a huge impact for a child in danger. And I don't have to give up a single freedom to recognize that. So I hope that you'll take people's concerns seriously. And if it takes some reassurance in the language to, maybe convince at least some people that this is not going to turn into some weapon against homeschoolers, which I don't see that it would be, make changes you need. But I do think that it does not hurt me or my family at all to just check my name against a list to see if there's an active protective order against me. So that is all that I have for today. And thank you for your time.
Thank you for your testimony, Steve, and for your transparency. Really appreciate you being vulnerable and honest with us. It's so helpful. I see that Senator Marr has a question or comment, so I'm going to turn it over to Senator Marr.
Thank you so much, Madam Chairman. Steve, no questions. I just wanted to thank you for understanding clearly both the intent and the hope of this bill of making sure that we are protecting children based on knowledge, experience, and history. Certainly not any way, a shape, or in any way, in any, sorry, it's late, in any shape or form, an attempt to hurt or diminish or demean homeschoolers. Not at all. It is purely just an idea and one of the to make sure that children are safe. And one of the things that oh man, it really is late. I apologize. I'm not even articulate. One of the things that we want to see is that in public hearings, we hear things that change the way we do legislation. And certainly today we did. And what we learned was we didn't go far enough in our explanation of what then happens to the names after they go to DCF. So we will fix that because we heard that today. They will be expunged. You know, it's really just a check. So thank you for understanding that. And I very much appreciated your testimony. And I apologize for babbling here. Thank you, Madam Chair.
Thank you, Senator Marr. Steve, did you submit a written testimony?
I did. I put the wrong attachment on there and I sent the correct one over to the clerk. So hopefully that'll be updated, but I did, yes.
Okay, great. Any other questions or comments from the committee? Thank you very much, Steve. Have a wonderful, wonderful night.
You too. Thanks so much.
Thank you. Gail, we are ready.
Excellent. Good evening, all. My name is Gail Shanley, and I am speaking to oppose Section 5 of SB 6. So my request is to amend SB 6 by removing Section 5. I'm a homeschooling mother of 5. You can see there's a little one right here. And over the last 20 years, I have known and taught hundreds of homeschooled students. Section 5 would sweep all withdrawing families into a state-level reporting system. It would create a chilling effect on families considering withdrawing to homeschool. It would implicitly establish a presumption of suspicion towards homeschooling families. It would expand government tracking without evidence that such a broad measure is necessary to prevent abuse. Child protection reform should really be narrowly focused and evidence-based. Section 5 is not narrowly tailored or even useful because it does not limit reporting to situations involving substantiated abuse or neglect. Section 5 treats the mere fact of withdrawing a child from the public school system as suspect. This is a violation of the foundational American principle of innocent until proven guilty. So my request is that you please remove Section 5 from SB 6. And that's it. Thank you all very much.
Thank you for your testimony, Gail. I see that Representative Dauphiné has a question for you.
Thank you, Rep. McGee. I just wanted to thank you for your testimony. The previous individual that testified, it really kind of, if you will, minimized it. And I think that you really kind of brought it right back to what it's speaking to many of the hearts and parents that homeschool with regard to they are presumed guilty before, you know, and the presumption is they're guilty until proven innocent. And I think that's really the takeaway here. Whether there's a list or not, nobody wants to be notified to DCF because we all know the only people that get notified to DCF are people that have done something wrong or presumed to have done something wrong or any kind of harm to their children. Nobody else has ever been notified to DCF. This would be a complete change in how we do things and operate in our state and probably most states. So thank you so much for your testimony. Appreciate it.
Thank you.
Thank you, Representative. Anyone else? Thank you for your testimony, Gail. Have a great night.
You too.
Seeing as I think believe it's been long. I believe this concludes our public hearing. I am turning it over to Senator Marr for final remarks and business.
Thank you so much, Madam Chair. Appreciate you running the last section of this public hearing. We are now at the end of the public hearing, and we're going to adjourn the hearing and reconvene the committee, the Children's Committee meeting. And now that we have reconvened the meeting, we are going to be in recess for 30 minutes. And at the end of 30 minutes, the Children's Committee meeting will be closed. Thank you all so much. Thanks everyone for being here. Really appreciate your time and attention today. Good night.
Thank you, guys.
Thank you, Mia.
Thank you, Mia.
Thank you, Mia. Thank you all, chairs. Thank you.
Mia, I assume you're taking votes, but I think I voted on everything. Can you just check for me?
Yeah, let me just, I got them right here. Yep, Senator Kushner, you're all good to go.
Thanks so much. Have a good night, everyone.
You too.
Good night.
Just wanted to double check the same. It was kind of hectic when I was voting, Mia.
Yep, you're all good.
Awesome. Thank you so much. I appreciate it. Have a good night.
Me too.
Mia, I missed 2 votes.
Yep. So we have, just grab them real quick.
I'm a yes for both.
Okay, yep. It's first one is HB 5268, and that's JF to the floor.
Okay.
And then the second one is HB 5270, and that is JFS, change of reference to the Appropriations Committee.
Yep. Thank you.
Mhm.
Good night, everyone.
And then Representative Comey, we are, let me just double check, but I
Just
believe
have that first one, I think, the first bill.
yeah, I believe it's just the first one. I'm just gonna double check really quick.
You guys move fast. Through that one.
Yep, it's just the first one. So it's SB 265, and that's JF, change of reference to the Appropriations Committee.
Okay, yes, Representative Comey votes yes.
Great, and you're good to go.
Thank you. Have a great night. Thanks for all your work.
Terrific. Thank you. Good night, Mia.
Have a good night.